Criminal petition is dismissed.
Obliged.
Therefore, bail stands rejected at this stage.
Item number 60.
Therefore, bail is allowed. 50,000 to CRTs. Therefore, bail is allowed.
Yeah, please, Lordship. I beg to mention item number 47, Lordship. Also not received, Lordship. End of day, Lordship.
47, CD not received.
I
did
mean,
not
interim,
receive.
Lordship. Interim may be extended.
Again on. Team order passed earlier to continue.
10th of February, madam. Interim is there. Interim is 10th of February. Obliged.
May I please, Your Lordship? I beg to mention item number 64. Consent of the other side is taken. Can this matter be taken after 2 weeks, Lordship?
60. The prayer of learned counsel for the petitioner and with the consent of the other side list the matter.
54 and 50. Oh, 64.
When?
After 4 weeks, Lordship.
Give a date after 4 weeks. Yes.
All right.
May I please, Your Lordship, Lordship for listening one regular way. And tomorrow, Lordship, petitioner is behind bar more than 2 months, since more than 2 months.
Press application.
Bishop.
Earlier rejected.
In trial court rejected, not high court.
Go to senior bench then. Senior bench is available.
May it please your lordship, may it please your lordship, I beg to mention item number 44, CD has not been received. Interim is there, so kindly pass over the matter for the day.
10-2, madam.
10 to interim to continue.
Obliged.
May I please, Lordship, I beg to mention item number 45, Lordship, CD not received, Lordship. Interim is there, Lordship.
Yes.
Obliged.
Please, Your Lordship. I beg to mention item number 23, Your Lordship. We've taken the consent of the other side. Objection in this matter is awaited, Your Lordship, from the department. Objection is awaited from the department, Your Lordship.
Item 23.
Yes, Your Lordship.
Prayer of learned standing council NCB. Consent of the other side. When?
Only herein I am the petitioner, Your Lordship. On so many occasions, they have time taken in the name of filing affidavit. So this may be as last chance, Your Lordship. On 21, Your Lordship.
Is submitted on behalf of the pet. Notice have been granted.
Yes, sir, on the 22nd, Your Lordship.
File their objection. The present adjournment may be granted only as a last chance. Para having regard to the above NCB. Submit its objection by the next date fixed, failing which the case will be taken up for adjudication.
Rashid, may I beg to mention item number 25, 30 and 40? Did this matter be taken after view vacation?
20.
25, 30 and 40.
20.
On the prayer of learned council.
30.
Krishna,
So,
the matter of February.
yes.
25 to
50 and 40.
30, 40.
Lordship, kindly be taken after view, Lordship.
Yes, after Bihu.
After view.
February is after Bihu.
In January only. In the last week of January, kindly. take
28
the
1.
matters.
28 1.
Grateful, Lordship.
May it please your lordship, I beg to mention item number 48, pair for Passover.
Item number?
48.
40.
48. Interim may be continued.
Did you not receive money?
Prayer of petitioner list again on. So, hearing order passed earlier to continue.
Matter may be listed after Bihu.
11 2.
Okay.
May I please, Lordship? Lordship, I beg to mention item number 36. It
Item?
is not 36, Lordship. Lordship, CD is not received.
36 CD not received.
Interim may be continued.
Yes.
Should I beg to mention listing of a anticipatory bill application for tomorrow?
But earlier rejected by this court. Yes, senior court.
May it please, Your Lordship. Your Lordship, I beg to mention item number 10, Your Lordship. Lordship, this matter may be adjourned for the day, Your Lordship. Some personal difficulty.
Head of learned council. Is the matter again. When do we want?
Lordship, after Bihu vacation. Hello, Your Lordship. Please, Your Lordship. Your Lordship, I beg to mention item number 29. It's a POXO matter. As per office note, the service was awaited, Your Lordship. Kindly matter may be taken like after Bihu vacation.
Head of council is the matter again on. February service is not complete. No?
10th.
10th of
10th February.
obliged, Your Lordship.
May I please. Item number 44, Lordship, 4 Lordship. Is there not received, Lordship?
Item number?
4.
On.
Obliged.
Lordship. I beg to withdraw bail application, Your Lordship, with the liberty to file a fresh.
You are? You are Mr.
Mohit Pandey, Your Lordship. I am appearing on behalf of Mr. Raj Chetri.
So and so Pandey, appearing on behalf of Mr. R. Chetri, prays for withdrawal of the petition is dismissed as file afresh.
Highly obliged, Your Lordship.
Pilot matter may be withdrawn.
Same order. Give your name.
HR Chaudhary.
What Lord? The matter may be withdrawn. Am Lordship.
Same order.
Wait, please, your lordship. Lordship, this is a regular bail application, lordship. In this case, lordship, FIR, lordship will find on page 13, lordship. And co-accused in this case, I approached the, before the coordinate bench, lordship has granted interim protection because of the assault. May I place that order of the co-accused? Is the case, lordship, what happened, the informant along with his wife, lordship, coming from to drop her wife in a home, lordship. This present petitioner, lordship, Lordship have their younger brother have a sand and brick shop, Lordship, and their Lordship one auto and pickup van was obstructed their road. In this case, Lordship, this informant Lordship asked the auto to that van to remove. Lordship, in this connection, Lordship, some altercation took place. Lordship, some unparliamentary word was passed and scuffle took place. Lordship, specific allegation against Ramjan Ali, that is the petitioner number 1, Lordship. Against rest of the Lordship, they have assaulted Lordship. Not much specific Lordship, only blow they have given. But against Ramjan Lordship, specific, he has assaulted with a belcher Lordship on the head of the informant wife Lordship. Already 33 days Lordship, it was because of a hot altercation Lordship, this happened Lordship. It's not required Lordship for the custodial integration or intensive investigation is required Lordship. Considering length of detention Lordship, 33 days in jail custody Lordship.
Page 29 of the trial court rejection order, madam. Last portion is relevant.
There are 3 petitioners Lordship, Ramjan Ali, Safiqul Ali and Rahim Ali.
No, according to the order passed by the other bench,
Yes, Lordship.
allegation is specific to you. That is why others have been granted bail.
Lordship, Ramjan against Ramjan, that is specific allegation Lordship.
Who is approaching today?
Ramjan, Safiqul and Rahim Ali Lordship. 3 petitioners. All us brothers Lordship, their brother Lordship.
Heard Mr. Council for Petitioner. TP. Present petitioners kita diban. As per the allegations contained in the FIR, accused persons along with other co-accused assaulted the informant wife on 4/12/2025. He specifically alleged that accused Ramjan Ali hit the informant with a helmet and tore the clothes of his wife. And the informant and his wife were tied to a post the roadside. Accused Muhammad Ramzan Ali inflicted a blow on the head of the informant with an iron belcher, the result of which the wife, the informant sustained grievous injury. Had to be admitted in the ICU, critical condition. Co-accused persons, namely Abdul Rashid Ahmed alias Ranju, Rahmatullah alias Rahmatullah Ali, and 3 Ali were granted interim pre-arrest bail.
May I, Lordship, Rahim Ali was arrested, so his name was.
Except Rahim Ali. Pre-arrest bail by order dated 5/1/26 in AB 3046 of 2025. Having regard to the above, number two, Muhammad Safiq Ali, alias Safiq Ali, and petitioner number 3, Ali, alias Rahim Ali, directed to be placed on interim bail. $55,000 each, with like amount each. And I got a call for the CD. Is the matter again on 21/1/26 along with AB 3046 of 2025.
To the satisfaction of CGM Kamrup Metro. Highly obliged.
My place, Lordship. Petitioner here is behind bar for 213 days, my lord. The offences are under the NDPS Act, section 22C and 2529.
Commercial.
Commercial amount.
Charge sheet case, my.
Charge sheet has been filed. So records will be
Submitted, the
called
charge sheet
petition.
has been submitted by CS number. There. Hence call for the scanned copy of the TCR along with CD. Again on. Give it.
TS number to go. My lord, on 17th of February, 17th. Charge sheet number to go.
My lord, may kindly call for seating, my lord.
All right. With it.
3rd of February, 3. I go to 3 January. 30.
Lordship, this is a regular bail application. Offences under section 4 and 6 of POCSO Act. I'm in custody for the last 518 days. I'm in so far. At this stage, Lordship, I'm praying that notice may be issued.
Third, learned counsel for the petition and learned additional PP. Is to the respondent number 2, also call for the scan copy of the KCR. Again on petitioner to take steps by registered post within 3 days.
Your Lordship.
Please, your lordship. Your lordship, herein the petitioner is charged under 103 of the BNS, lordship. Petitioner is behind the bars for the last 435 days. Trial is not proceeding as planned. W1 has been examined till. That is a page number 10, lord.
Ashited,
Yes, lordship.
charge sheeted case for the scan copy of the TCR along with CD. List again on.
Six February.
Yes. See, FI is space 10, my lord, type copy. Original is space 13, my lord. Allegation is being serious, my lord. And CD may be called for, my lord.
Alright.
And 2020.
29/1.
Come from Boko, my lord. 21, 22.
22/1.
Published.
The quantity is there.
Commercial quantity. CD.
19 February. 19.
The lordship. Lordship, another case is pending.
Speak up, I can't hear you.
One another
Lordship.
case is pending regarding the same affair that is fixed on 28/2. 28/1.
28/1.
28/1.
List the matter along with
AB number 294225.
on 21. Yes.
Epistolars. In this case, my lord, one altercation and scaffold take place on 24/10, my lord. After 10 days of this incident, FIR was lost by both the parties, my lord. And no explanation was made in respect of delay, my lord. And subsequently, my lord, we are the actual victim, my lord. We got injuries, my lord. These are report is there. And both parties were arrested and they were subsequently released in bail. Only I am remaining whose name is in the FIR, my lord. This is the case, my lord. In fact, everything is settled, my lord. Amicably settled, both were granted bail, my lord. May I read, madam? Page 4, para 5, my lord.
Your FIR is at page?
My FIR, our FIR, my lord, our FIR, my lord, this is page 24.
Hmm?
Page 24, which we have filed, my lord. It means my brother filed. I was not there, my lord.
Why are you here after so long?
My lord, because my two brothers and fathers were arrested. Subsequently, my lord, they were got bail, my lord. Because I was not in search, because although I am the very young boy, my lord, not in that particular group, my lord. Because our father and brothers were attacked by the informant side, my lord. This is everything in record, my lord. I have annexed some medical records of my brother and father, my lord. Page 31 to page 648, my lord. This is the medical records, how we got injuries by their attack, my lord. Page 31, my lord.
Regarding the other arrested accused person, one forwarding report is annexed. That is at page 17. Well.
But they were subsequently released on bail, man. Granted bail. Is the bail order.
As regards the present FIR, all the others have been granted bail.
Granted bail, man. All have been granted bail. In fact, my lord, everything is settled. After 10 days of the alleged incident, FIR was lost. Because matter was amicably settled. Just to harass us, my lord, they filed this FIR. And court granted bail, my lord. So, my lord, nothing remains in this case, in fact, my lord. Since my name is there, my lord, so I approach before this honorable court for apprehension. A charge sheet is not yet filed, my lord.
Seems that, my lord, he is one of the main accused, because of which, my lord, he has not, till now, he has not approached before this honorable court, and while after all the other accused persons, my lord, obtained bail, my lord, now
They got bail just before closing of this honorable court, my lord. After 10 days of alleged incident, even the explanation is not given why the 10 days delay is there, my lord, in the FIR.
I'd heard done it counsel for the petitioner. Petition under so and so. As per allegations contained in the FIR, the petitioners attacked the members of the informant side with dao, stick and other weapons, because of which the informant side sustained injuries. Where it is submitted, FIR was lodged 10 days after the alleged occurrence. And in this regard, the present petitioner side had also lodged an FIR, which is annexed to the instant bail application. Further stated that the other co-accused who were arrested have been released on bail. There are call for the CD. There are having regard to the facts and circumstances above, it is provided in the interim. In the event of his arrest, the petitioner so and so released on interim pre-arrest bail of rupees 50 security like amount to the satisfaction of the arresting authority. Further provided that cooperate with the investigation. On
17-2.
Bless.
May I please your lordship? Three petitioners are before your lordship, my lord. Lordship will find the FIR at pay scale. My lord, accused persons as shown in the my lord FIR 1, 2, and 3 are before your lordship. 4 and 5 have been granted, my lord, anticipatory bail by the my lord Sessions Court. And Habizul Islam, my lord, he is about 19, 20 years of age, my lord. He was arrested, my lord. And FIR is, my lord, regarding, my lord, occurrence of 3/11/2025.
6 is arrested already.
Yes, my lord. 6 is arrested. 6 had the love affairs with the my lord.
4 and 5 granted bail.
4 and 5 have been given anticipatory bail, my lord. My lord, there's a love affair between the my lord, the accused number 6 and the my lord niece of the informant, my lord. And for that, my lord, they have written, my lord, that we all in a group, my lord, came to solemnize the marriage in the my lord, that girl's house, my lord. And they are just my lord, next door neighbor, my lord. Regarding, my lord, this love affairs, my lord, because the boy is about, my lord, 19, 20 years, and girl is about, my lord, 21, 20, my lord, 21, 22 years, my lord. Because of that, my lord, there was some dispute between the, my lord, these two families, my lord.
Where is the order of the session judge?
As section judge, I have annexed, my lord, that the long order, my lord, lordship will find at, my lord, page 15.
Present petitioners are Babul
Yes, my lord. Babul Hussain,
Sekanda.
Sikandar Ali,
Anar-
Anarul Islam. They are the, my lord, the Habizul Islam's, my lord, uncle, my lord.
Okay, since the
Uncle's son.
session judge has observed that there are serious incriminating materials against the three of you, page 17 last.
Yes, yes, it is there, my lord. It
Call
is
for
there.
the CD for now then. That Mr. M. Chaudhary, Learned Senior Counsel. Learned Additional PP. Peruse the order passed by the Learned Session Judge, whereby the prayer for prayer is bail in respect of the present petitioner. So it is deemed necessary to call for the CD.
From 21 to 0.
Is the matter again on?
21, 1. I'm obliged, lordship.
Yes, your lordship, I oppose. Lordship, item number 9. Connected matter is fixed on 22.
9.
Yes, Lordship.
Huh?
Item number 9.
22, all right, 22.
This will pass over for time being.
All right.
Please, Your Lordship. Lordship, this is a classic cross FIR, Lordship. Case against arising out of a long land dispute, Lordship. Lordship, before going to the FIR, Lordship, Lordship kindly may come to the page number 23, Lordship. This is the FIR which was lost from our side, Lordship. And the photograph, Lordship, this is page number 23 for a moment, Lordship. Informant and their family members, Lordship, they were, Lordship, assaulted us, Lordship, and grievously injured us, Lordship. Then, after knowing the lodging about this FIR, Lordship, they lost this counter FIR, Lordship. Both side, Lordship, they are the family members, Lordship. Lordship, and the petitioners are there, all the petitioners are own brothers, Lordship. They are the siblings, Lordship. Lordship, at this stage, Lordship, we may be protected, Lordship, and so, Lordship, Kejidari may be called for, Lordship.
Page 29 is the rejection order. Page 29 is the rejection order of the learned session court, my lord.
29.
Page 29, that is relevant portion, my lord, from paragraph 2 and 3.
Lordship, in the page 29, Lordship, second para, Lordship, it is stated that one Abu Somet is grievously injured, Lordship. But all both side, Lordship, is the family member, Lordship. In our family, Lordship, no Abu Somet is present, Lordship.
After perusal of CD, a prayer was rejected. We have to see the CD before granting you any
And
kind of
Lord-
protection.
All the petitioners' brother, Lordship, and all the male family members were, Lordship, implicated, Lordship. Lordship, interim may be granted, Lordship. We will appear, Lordship. And we were, Lordship, grievously injured, Lordship, and we are under treatment, Lordship. At least, Lordship, we may be protected, Lordship. Lordship,
Passengers is
Lordship, for a
rejected
moment,
after
Lordship,
perusing the CD. How can we grant you interim protection?
Lordship, for a moment, Lordship, kindly may come to the page number 21, Lordship. As per their FIR, Lordship, they stated that local people came, Lordship, and they rescued them. And after 2 hours of the incident, Lordship, they arrived at the police station, Lordship. And there is no GD entry. And they stated that police took them to the hospital, Lordship. And for a moment, Lordship, kindly may come to the page number, Lordship, 22, Lordship.
Now, what difference does that make?
Lordship, in the GDA, Lordship, GDA number is 420, Lordship, and dated is, Lordship, 30/9/2025. But as per their FIR, Lordship, incident was occurred on Lordship 28, Lordship, 28/9/2025, Lordship. Without
28?
GDA 28/9. But FIR was lost, Lordship.
28/9. So since then also you have been at large. You can easily wait for another week.
Lordship,
Yes.
police is searching, Lordship. We
Call
are
for
also
the
under
CD.
treatment, Lordship. Lordship, at least may be protected, Lordship, at this stage.
No, that is not the practice.
GDA also reflect this, Lordship, case was lost, Lordship, 30 after 2 days of the incident, Lordship. But in the FIR, they stated that they arrived on that day at the police station. But
But the
without
material was found against you in the CD at that time.
Lordship, Abu Somet, he was not a present, Lordship.
Yes, yes. Give the date.
Lordship, kindly pass over for time being.
Maybe. This is a bail application, my lord. Or one is the purchaser of the cattle, application number 2 is the registered owner of the vehicle, my lord. And in this case, my lord, 3 persons were arrested. They were learned court below, they were enlarged on bail, my lord. And petitioner were approached before the learned court below for paying for Zimma. That's also be allowed, my lord. Lordship will find page F8 page, my lord, 11, my lord. Please translate copy, my lord. Original is page 18, my lord.
And when the Zimbabwe order, my lord, page 37. Cattle and raised vehicle, my lord, is given Zimbabwe, my lord. Now petitioner is before lordship paying for interim protection for receiving their articles, my lord. And major part of this case, my lord, investigations have been completed in the reflected, my lord, in the bail order, my lord. Page 42, my lord. Petitioner, they annex their receipt, my lord. This annexure 2, page 20 to 35, my lord. From 35.
You are the owner.
My lord. Case number 1 is the
Both are owners.
purchaser of the cattle. 2 is the vehicle owner, my lord. The bail order, my lord.
Yes, where is the bail order?
Bail order, my lord, page 37, my lord. So it's 41, my lord, 41. 41. Or para, my lord, page 42. From the page of the case, it appears that the major part of the investigation has already been done by the IO. That apart from the accused person are in judicial custody since 10/12/2025. There is also no prayer for from the side of the IO further detention of the accused person in judicial custody.
What is there to show that you are the purchaser?
My lord, page 20, my lord.
Hmm?
Page 20, my lord. Page 22. 35, they are these are the receipt.
First of all, my lord, prima facie cruelty is attracted because in a my lord vehicle they carried my lord total 44 numbers of kettles, my lord. Only 6 numbers of kettles is permitted in even in a my lord big size good carried vehicle also. And here 6 kettles died. So prima facie my lord cruelty is attracted. And regarding those documents which he has now annexed in the petition, only IO can verify the genuineness of all those documents.
Yes, well, I will appear, my lord.
Prima facie cruelty is attracted.
Hmm. All right, we'll have the CD then. Purchaser means you were present there.
Hello?
You are the purchaser, so
My-
you were present there. You loaded them, loaded the animals, overloaded them rather. Learned Council, PP. All for the CD. Matter again on.
21-1.
Only pay, my lord. My lord, my vehicle is lying here, my lord, the outside, my lord.
That is a Zimma.
Yes, my lord.
Question of Zimma.
Yes, yes.
Then
That has been given, my lord.
yes.
But I could not collect, my lord.
That is the reason why it has been given, because it is going to get damaged.
Only interim production, my lord. In the meantime, I will appear, my lord. I will participate in the investigation, my lord.
Everybody can say that.
My lord, here, the petitioner, he is a registered cattle trader, my lord. Page 13 is the registration certificate, my lord. While transporting, my lord, 20 numbers of cows, my lord, his vehicle was, my lord, vehicle and the cows was seized by the police, my lord. And page 14 is the, my lord, sale certificate, my lord. Now, my lord, he has.
Who are you?
Yeah, my lord, he has moved the Zimma petition before the, my lord, learned SDM Hazu, my lord. But my lord, Hazu, SDM Hazu has directed to, my lord, appear the petitioner before the IO to ascertain the ownership of the vehicle and the cattle. By his appearance, that on his appearance, my lord, he may be, my lord, arrested. So, my lord, to ascertain the, my lord, ownership of the, because he's a registered dealer, my lord, this is Obonori Enterprise Losses come to page 13, my lord. And this is the order, my lord. It was fixed on 29, now 21, 2026, because I was on leave, my lord. Only to ascertain, my lord, he has to appear before the IO, my lord. That is why. And the vehicle is also, my lord, this is a livestock carrier, my lord. And sales certificate is as page 14, my lord. And original receipts, my lord, that are seized by the police in the seizure list, my lord. It is fixed on 20th of January, my lord, because I was not there, my lord. He was on leave, so, my lord, on PM duty, my lord. That is why, my lord, we have to take time, my lord. So, my lord, to ascertain the...
Authorized person can also appear.
My lord, what happened, my lord, the owner of the vehicle, when he, my lord, appeared, after taking Zimma, he is also arrested. That is why, my lord, I am bringing.
Yeah.
And the Zimma order, this is here, my lord. Zimma order is there. Vehicle owner is arrested, my lord. That is why, because he is a registered cattle dealer under the government of Assam, my lord. Only to ascertain, my lord, these documents, my lord, to produce before the IO, my lord. Some protection is needed, my lord. While, my lord, he went to, my lord, the owner of the vehicle went to take Zimma, he was also arrested. These are genuine cattle, my lord, and registered sales certificate is also there, and original, my lord, in the seizure list it is mentioned 9 numbers of, my lord, receipt, sale, purchase receipts for Bagbor Bazaar, my lord. These are, my lord, not stolen, my lord, cows, my lord. These are genuinely purchased by the petitioner. He is a registered dealer, my lord, or trader, my lord. So, my lord, I am praying, my lord, only to, my lord, ascertain his ownership, my lord, he have to appear before the IO. So, my lord, to produce the documents, my lord. FIR, my lord, will find...
Dealer means what? You are the seller.
No, I am the purchaser. He's a trader, my lord. He's a registered trader under the veterinary department, my lord. That is the page 13, my lord. Lordship, kindly see, Nityananda Kaman, my lord. He purchased the, my lord, this, his farm purchases, my lord, the cattle and used to sell in different parts of Assam, my lord. He was transporting from Bagbor Bazaar, Borpeta to Silchar, my lord.
Yeah, beyond the capacity.
And suppose
Yes, that is true, my
suppose he
lord.
is a registered dealer.
My lord,
Why
capacity, my lord.
At the time of apprehension, why at that point of time he?
No, my lord,
pretended
lordship,
to be
kindly see page 15, my lord. Page 15, my lord. Actually, my lord, 15 numbers of cows are allowed in that vehicle. It is by the veterinary department.
No,
But
my
his
lord.
employees, my lord, loaded, my lord, 20 numbers. 5 numbers exceeded, my lord. But these are not stolen cows, my lord. Genuine cows, my lord.
As per rule 56 of the my lord, cruelty to animals act 1960, my lord, only 6 vehicles in a my lord heavy my lord, goods carrying vehicle, only 6 cattle allowed.
No, it is now amended, my
Veterinary
lord.
department can allow 15 numbers of.
No, 15,
cattle, my
as
lord.
per size of the vehicle, my lord. It is in the rule, my lord. It is in the rule, my lord, as per size of the vehicle, my lord. Size is mentioned, my lord, in the 15 page 15, my lord, of certificate, my lord. And everything is under, my lord, control of the veterinary department, my lord. And trading license is also, my lord, issued by the veterinary department. They determine the number of, my lord, cattle, how many numbers of cattle can be transported as per size of the vehicle. Only to ascertain, my lord, to submit this document, my lord, the petitioner needs some protection, my lord. That is why I am before your lordship, my lord. It is not that case, my lord. He is a, my lord, smuggler or that, my lord. His farm is registered under the veterinary department, my lord. And my lord, actually, the petitioner, who is the, my lord, proprietor of the farm, in his name, my lord, his agents purchases and transports, my lord.
Where have you stated that?
Paragraph 4, my lord. Aminul Mia Bagbo Clive to sell it to the petitioner. The certificate were purchased. My lord, Aminul Mia, he purchased the, my lord, from the Bagbor Bazaar, and then, my lord, in the name of, my lord, this, my lord, sale to the, my lord, this petitioner. He took the, my lord, Aminul Mia, my lord, took the, my lord, that, my lord, 20 numbers of cattle, my lord. It is in the page 14, my lord, roughly reflect.
No, who was transporting?
My lord, it is Aminul Mia. He is the buyer, my lord. Aminul Mia sold, my lord, him, when he transports and he delivers in Silsor, my lord. That is the, my lord. Petitioner never goes, my lord, to, my lord.
You are the final purchaser.
I am the final purchaser. He, my lord, Aminul Mia purchased from Bagbor Bazaar, then it will deliver in the Silsor in his, my lord, farm, my lord. In between, my lord, in Hazo, it was, my lord,
Third learned counsel for the petitioner, petitional PP. This is an application under Swens. As per the FIR, one vehicle carrying registration number AS01 NC 9425 carrying 20 numbers of live cattle was apprehended by the police on 15/12/25. But the driver and the handyman managed to escape. The vehicle as well as the cattle have been seized. Submitted on behalf of the petitioner that he is the final purchaser of the said cattle. He is registered under the veterinary department as a dealer of cattle. Regard the registration certificate has been annexed as annexure 2 to the instant petition. is further submitted that petitioner was in no way involved in the transportation of the cattle. He was supposed to receive the cattle at his farm,
Silchar, my lord.
Silchar. Is further submitted that this order was passed by in a Jime petition.
Both, my lord, one for the vehicle, by the vehicle owner, and other by the, my lord, it was fixed on 28, but I was not there, so we took, take time. It is now fixed on 28.
Submitted that order dated 24/12/25 passed by the MFC Hazo. In a Jima petition in respect of the cattle. Direction was given to the petitioner. Any person authorized on their behalf to approach the IO with documents for ascertainment of the ownership of the cattle and vehicle. Therefore, the petitioner apprehends that he may be arrested as and when he appears before the IO, inasmuch as the owner of the vehicle was arrested upon his appearance before the IO. All for the CD. With regard to the aforesaid facts and circumstances, it is provided that in the event of his arrest shall be released on interim pre-arrest bail of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. It is further provided that the shall cooperate with the investigation. Release the matter again on
Highly obliged, madam.
May I please, your lordship? Lordship 482 BNSS application, your lordship. FI is at page number 11, your lordship. The vernacular portion starts from 11, your lordship. Even FI is at page number 12, your lordship. The vernacular, your lordship. Lordship, may I read the FIR, lordship?
Yes.
Yes, your lordship, what is the case here, your lordship? A 50 years old widow, your lordship, implicated, your lordship. The accused person falsely implicated, your lordship, alleging that he committed rape on that lady, your lordship. Now, the case is that, your lordship, yes, lordship, this is a consensual relationship between the petitioner and the informant, your lordship. Because the petitioner is a married man, your lordship, and maintaining an extramarital affair with that lady, that is true, your lordship. The thing is that, Your Lordship, why I'm saying this is falsely implicated, Your Lordship, if Your Lordship kindly peruse the FIR, Your Lordship, it itself reflects, Your Lordship, because the incident was alleged to be happen on 27 December 2000 to 27/11, Your Lordship, 2025, Your Lordship. Now, if Your Lordship kindly see the page number, look into page number 11, Your Lordship. The information received date, Your Lordship, that is 12/12/2025, Your Lordship. That is 16 days delays. Again, if Your Lordship kindly see, look into the page, Your Lordship. That page number, Your Lordship, starts from the typing copy starts from 13, Your Lordship. There is a complaint, Your Lordship, initiated by the petitioner, Your Lordship, against the informant and two other persons, Your Lordship. One is the brother of the informant and another was the laborer, Your Lordship. Here, Your Lordship, what happened, Your Lordship? The petitioner maintained her whole needs, Your Lordship, basic necessities, even fees of the children, fees of the girl child of the informant, Your Lordship. Now, when the wife of the petitioner got to know that there is he's maintaining a illicit relationship with that informant, Your Lordship, that everything has been stopped thereby, Your Lordship. So that is the outcome, Your Lordship. The FI is the outcome of that thing, Your Lordship. And if Your Lordship kindly look into the complaint petition, Your Lordship, that has been filed by the petitioner on 3rd of December, Lordship, much earlier than the FIR, Your Lordship, alleging that it was an allegation that, Your Lordship, the 27 December 2025, Your Lordship, the informant invited, Your Lordship, the petitioner, Your Lordship. The complaint petition is that, Your Lordship, and the case is pending, Your Lordship, that it had been registered at CR 1116/2025, still pending before the Court of Sankardev Nagar, Your Lordship, Hujai, Your Lordship, Chief Judicial Magistrate, Your Lordship, for adjudication, Your Lordship. And if Your Lordship kindly again come to, with due respect, Your Lordship, again, number 12, Your Lordship, again, look into page number 12. One paragraph, Your Lordship, one lines I'd like to direct the attention of Your Lordship, Your Lord. That is, Your Lordship, যোৱা ইংৰাজী 27/11/25 তাৰিখে উপৰোক্ত আসামীজনে মোৰ ঘৰত কোনো নথকাৰ সুযোগ লৈ বলপূৰ্বকভাৱে মোক সাৱটি ধৰি মোৰ ইচ্ছাৰ বিৰুদ্ধে মোৰ কাপোৰ কানি টানি খুলি মোৰ লগত অবৈধ শাৰীৰিক সম্পৰ্ক স্থাপন কৰে। মই চিঞৰ বাখৰ কৰাত মোৰ ছোৱালী দেখি ওচৰ চুবুৰীয়া লোকক খবৰ কৰা ওচৰ চুবুৰীয়া ওলাই অহাত আসামীজন পলাই যায়। Your Lordship, firstly, she alleged that there is no one in her house, Your Lordship. After that, the girl child appeared, Your Lordship. From the perusal of the FIR, Your Lordship, it's a long FES, Your Lordship, it's a falsely implicated case against the petitioner, Your Lordship. Your Lordship, among the judgment, Your Lordship, from Kerala High Court and Your Lordship, Honorable Supreme Court, Your Lordship, I would like to, from both of the cases of Kerala High Court, Your Lordship, where in falsely implicated cases, bail has been provided, Your Lordship. Anticipated bail has been provided, Your Lordship. I'm providing this to judgment, Your Lordship.
What is this complaint at page number 13?
Lordship.
There is no name. Who lodged this complaint? Page 13.
Your Lordship.
There is no signature in the complaint.
Who is complainant? Who is nothing is there.
And regarding
Your Lordship, that is page number 16, Your Lordship. The vernacular portion I'm in, Your Lordship. It is the complainant is Biren Nath, Your Lordship. That is not visible, Your Lordship. It's my apology.
That is what should have been typed. You have to type the whole complaint, not in parts.
Otherwise, it is Biren Nath, Your Lordship. That is the petitioner itself, Your Lordship, who complained against, Your Lordship, the three Pappu Harijan, Darbanti Devi, Minoti Devi. The third number accused person is the informant in this case, Your Lordship.
And regarding the submission of my learned friend, my lord, regarding that this is a false case and citing one, my lord, decision of the Honorable Kerala High Court, my lord, regarding how she can say at this stage that this is a false case, my lord. Well, from the FIR itself, it reflects that on 28/10/24, my lord, the present accused person has signed a compromise agreement for committing the same kind of incident, and that was submitted before the police station. And again, on, my lord, 27/11/25, my lord, the present FIR has been lodged for committing the same kind of offense.
I am saying this, your lordship.
So how can now at this stage she can say this is a false code? That will come later on, my lord, but this is not the, my lord, appropriate stage to
Because
say
I am
that this is a
saying these
false
things,
case.
your lordship. It
But
will,
from the allegation in the FIR now, there are sufficient materials against the accused person, ma'am.
I'm saying this at this point of time, your lordship, because from the perusal of the FIR itself, your lordship, reflects the falsely implicated case, your lordship. Because the girl child was not there. There is no one in his house, in her house, your lordship, in her residence. And suddenly the girl child appeared and seen the whole evidence, witnessed the whole incident, your lordship. So from itself, your lordship, the FIR itself reflects, your lordship. And the complaint petition is much earlier than this, your lordship, than this FIR, your lordship. Because of the petitioner stopped paying her fees, your lordship, basic necessities, your lordship. This is the outcome of that thing only, your lordship. So at this stage, lordship, looking at this age of the this informant, your lordship, or the lordship petitioner, your lordship.
What is the age?
The victim, the informant age is 50, your lordship, and the petitioner age is 53, your lordship. And it was a delayed registration, your lordship. 27 December
What is the
2011.
date of your complaint?
The company is 3rd of December, your lordship. It is one of the copy, your lordship, I have provided from E-Court, your lordship.
3rd of December 25.
25, your lordship.
And the FIR?
FI was 12 December, your lordship. 12 December, lordship. Even there is no GD entry, your lordship. On 12 December only police got the information, your lordship.
Third, learned counsel for the petition and learned additional PP. An application under so and so. The informant lodged an FIR on 12/25 against the present petitioner, alleging at Hosai PS, alleging inter alia that the petitioner
Lonka PS, my apology, your lordship. It's a Lonka PS, your lordship.
yes, alleging inter alia that the accused person used to enter her house forcefully, taking advantage of the absence of anybody else in the house. And on 27/11/25, the petitioner hugged her forcefully and taking advantage of the absence of any other person, removed her clothes and had illicit physical relationship with her. And when she made hue and cry, her daughter saw her and informed the neighbors who arrived at her house, whereafter the petitioner ran away. The learned counsel for the petitioner submits that to the date of alleged occurrence is 27/11/25. The FIR was lodged only on 12/12/25. Before that, on 3/12/25, the petitioner had lodged a complaint against the present informant before the CJM Hojai, alleging that he was assaulted by the present informant along with others on 27/11/25. That is the very day of the alleged occurrence of the present FIR. It is further submitted that the instant FIR has been lodged as a counterblast to the complaint lodged by the petitioner on 3/12/25, copy of which has been annexed to the instant bail petition. A call for the CD having regard to the aforesaid facts and circumstances. Condition. The matter again on
24/2.
Lordship, the FI is at 482 petition, Your Lordship. The FI is at page number 11, Your Lordship. Allegation of transportation of 18 numbers of cattle, Your Lordship. It's a buffalo, Your Lordship, using one truck, Your Lordship. Here the petitioner number 1, Your Lordship, is the purchaser of those 18 numbers of cattle, Your Lordship. And petitioner number 2 is the registered owner of this vehicle, Your Lordship, who has alleged they have been used for the transportation of smuggled cattle, Your Lordship. Now, Your Lordship, at a time of interception by the police, Your Lordship, the handyman and driver failed to produce, Your Lordship, the purchase receipts and documents, Your Lordship. For that reason, Your Lordship, the case has been registered, Your Lordship. Though I am not the FIR name accused, Your Lordship, I have all the receipt, Your Lordship, starts from page number, annexer 3 series, Your Lordship, starts from page number 20, Your Lordship, to 25, Your Lordship. The original receipt, Your Lordship, whereby, Your Lordship, the petitioner number 1 purchased, Your Lordship, from the market and Kathiatali Anchalik Panchayat, Your Lordship, issued those receipts, Your Lordship. These are the original receipts, Your Lordship, for your perusal, Your Lordship. Your Lordship, the ordinate functions in this type of cases, Your Lordship, given interim protection, Your Lordship, Honorable Guwahati High Court, Your Lordship.
yes, PP.
Prima facie cruelty is the 18 numbers of buffalo, one buffalo, my lord, found dead, my lord, and thereafter, how, my lord, they in a cruel manner, they transported those, my lord, cattle in the vehicle, my lord. 18 numbers of cattle, my lord, which is not at all permitted, and those, as such cruelty is prima facie there, and regarding those documents, my lord, Those regarding genuineness of these documents at this point of time, it is difficult to say. Only IO, my
Your
lord.
Lordships,
Receipt
that
of
reason,
the
your
case
Lordship,
diary, my lord.
protection may be given you so that I can submit those documents, your Lordship, before the IO, and they can verify the same, your Lordship, whether that are genuine
In
or
all
not, your
cases, my
Lordship.
lord, at the time of apprehension, they failed to produce all the documents, and thereafter, when case filed, they annex all these documents along with the bail petition.
One chance may be given,
all
your Lordship,
cases.
so that I can verify those documents
Only
by the
ground that
IO,
at
your
that point
Lordship.
of time, they could not produce. So
And the
if you were
cruelty-
transporting such a huge numbers of kettles, why you have not keeping those, my lord, documents
Because at that time, your Lordship,
and
I was
failed to
not there,
produce
your
at the
Lordship.
time of verification by the police, my lord?
At that time, I was not there in the
Prima facie,
vehicle,
it
your
seems
Lordship.
that the genuineness of those documents.
If any Lordship, any allegation against me after, on the event of receiving the CD, your Lordship, my bail may be cancelled, your Lordship. But at this event, your Lordship,
See, will, my lord, genuineness.
at this event, your Lordship, after your Lordship may kindly give a.
You may or may not be there, but if it is a bona fide purchase, what is the explanation for absence of documents with the driver or handyman while transporting it? How can you transport vehicles, these cattle without any documents?
Those Xerox copy of documents was there, your Lordship, with the driver and handyman in their mobiles, your Lordship.
Why Xerox copy?
But in their mobiles, your Lordship, but don't know why they have don't provided those things at that time, your Lordship. So Lordship kindly give a chance, your
The
Lordship.
vehicle was being chased or had to be chased.
In the police, your Lordship, those are the laymen, your Lordship, driver and handyman, and they have already been arrested, your Lordship. They've already been arrested, your Lordship.
And that
My
itself
my kettles, the
shows the transaction is fishy. You are the owner of the vehicle, another is the purchaser, but there is no document.
one chance may be given, your Lordship, so that your Lordship, otherwise on the event of receiving the CD, your Lordship, Lordship may cancel my bail if any allegation against me, your Lordship. Those has been smuggled. Those are not smuggled kettles, your Lordship. My humble prayer, this, your Lordship.
Right, those documents, my lord, which were annexed at this point of time, those documents are, although I cannot say whether regarding the genuineness of those documents, but they are those documents itself, my lord, doubtful whether these are own created or in fact, my lord, truly genuine or not, my lord.
What is the case without Lordship verifying those documents, your Lordship? The police also can't say, your Lordship. The Lordship may kindly give the one entry protection, maybe protected Lordship at this time so that I can appear before the IO, your Lordship, and submit all those documents, your Lordship.
For that, you don't need to appear, just send the documents through your authorized agent.
Otherwise, my kettles are there, your Lordship. My kettles are also there, your Lordship. My Jimma petition is pending, your Lordship, before the Morigaon court, your Lordship.
Your cattle has been taken care of now. Better care than you were taking.
Because 300 rupees fine.
One
has
of
been
them
imposed.
died while transportation.
300 rupees fine has been imposed on daily basis, your lordship, for those cattle, your lordship.
And that the Zimma
Without-
petition is to take care of.
Lordship, without, with due respect, your lordship, without my appearance, your lordship, that is not possible, your lordship, to verify all those documents, your lordship. So one chance may be given, your lordship, at this time, your lordship. Any condition, lordship.
We'll give a short date now because prima facie cruelty is there because of the death of the.
Lordship,
bull.
kindly see cruelty, but only
Yes.
attract, your lordship, fine itself, your lordship. My humble prayer, your lordship, with due respect, your lordship, at this time, your lordship. Otherwise, lordship can cancel it on the event of receiving the case diary, your lordship. If prima facie allegation is there as against me, your lordship. My humble prayer at this time, your lordship. Protect me, your lordship.
No, we'll see after receipt of the CD.
Lordship, it's a vacation will started, your lordship, a BU vacation, your lordship. Lordship, considering, with due respect, your lordship. Humble prayer, your lordship.
We have expressed our mind already.
BU vacation is there, your lordship, so it will start hereby, your lordship.
Has it got to do with you? Come after 10 days anyway. Takes on 21st, okay. CD, huh?
Please, your lordship. Lordship, this criminal petition is filed by challenging the order dated 20 September of 2025. Page number 18, my lord. Last occasion, my lord, report was called for confiscation proceeding.
That report not yet received, my lord. Any short date may be fixed. I will get the report, my lord.
Any report was called for?
My lord, several times report was called for, my lord.
Present status of that confiscation.
Already 3 times, my lord. Yes. My lord, last part of the order, my lord. Page number 19. Actually, my lord, this says vehicle was kept in the Thana. There is mentioned, my lord. I read. Last page. District Agriculture Officer, Kamrup, the sage fertilizer and the vehicle mentioned above have been confiscated at Zurabad Police Outpost, and Sri Shankar Datta so has been duly authorized to initiate further proceeding under section
so of Essential Commodities Act 1955. Furthermore, as per order number so dated so, the says urea fertilizers are to be auctioned and interested parties have been requested to visit the shortage site prior to submitting quotation to the auction committee. Since the fertilizer are presently stored within the seized vehicle themselves bearing so and due to unavailability of alternative storage space at Zoradbat outpost, the release of the said vehicle on Zimma at this stage is not feasible. Considering the above mentioned reasons cited in the Zimma report and being satisfied by IO, I do not see it fit to allow the Zimma. My lord, actually, the vehicle is keeping in the inside in the Thana for keeping the fertilizer.
Yes.
My lord, the
Who is the owner of the vehicle?
owner of the vehicle, my lord, petitioner give a power of attorney and he is dealing with the vehicle. Owner of the vehicle named Mohar Ali. My lord, page number 17.
No, what is wrong with this order?
My lord, actually,
It is already up for confiscation, auction.
my lord, actually, confiscation is proceeding going against the fertilizer, my lord. Only 280 bags of fertilizer and along with the vehicle was seized by the police. My lord, if the vehicle is keep here, it is seized on 13/6/2025, my lord. It may be destroyed, my lord, and it is, my lord, this vehicle is financially, my lord, it is fine. One is suffering from financially, my lord.
Whereas, my lord, that confiscation proceeding was initiated by the district magistrate. Only those, my lord, vehicle along with those with the fertilizer were kept in that police campus, my lord. From the order, it reflects that. Regarding that aspect, my lord, whether those, my lord, after initiating confiscating proceeding about the present status of those, my lord, fertilizers and the fertilizers were loaded in the vehicle. So I will have to. Otherwise, my lord, if the proceedings are initiated by
The vehicle can't be given to him without unloading the fertilizer.
Yes, my lord.
So that is the main point.
My lord, there is.
And my lord, there are also provision in the essential copy. I will point out later on. Right now, not with me, my lord. While proceedings initiated by the district magistrate, in fact, my lord, the appropriate authority, they will have to approach before the district magistrate. In any case, my lord. Regarding that aspect, my lord, I will have to.
My lord, several times, 3 times, a report was called for by this honorable court.
Who asked you to come to the High Court? Why didn't you go to the Sessions Court? Since you have chosen to come to the High Court, you will have to wait. And the easier option was there. You could have got it a short date. You have chosen this forum. Yes, report is called for has not been received. IO is directed to furnish the report on the next date fixed.
My
List
lord,
again on.
my lord,
28-1.
my lord, my simple submission is there. Section 6A of the Essential Commodities Act 1955. There mention 6A last para provided further that in the case of any animal's vehicle, vessel or other convenience used for the carriage of goods or passengers of where the owner of such animal, vehicle, vessel or other convenience shall be given an option to pay in lieu of its confiscation a fine not exceeding the market price at the date of sales of these essential commodities sought to be carried by such enemy.
So have you filed any application for that before the appropriate authority?
I am praying before this honorable court by any condition, my lord. The Zimma is
Now,
allowed.
you are quoting a paragraph. I am asking you whether you have yourself complied with that, availed of that facility. Yes, next.
Date may be. Obliged.
This, Your Lordship. Lordship, this is an application under 528 of BNSS. Praying for setting aside of order of the additional district and session judge. Today, the report was called for from the FSL.
This is for mobile phones.
For mobile phones.
As per my verbal instruction, my lord, one of my friend, he communicated with the IO, my lord. This is the, my lord, all evidences are, my lord. The vital piece of evidence, my lord, in the case.
Lordship, it's already 2:54. Taken several times for submitting the reports. The lower court rejected my petition only on the grounds that the phones are vital evidence and they are yet to be sent to the forensic lab. That is the ground of rejection. Page number 11, Lordship.
This says it may be released now.
Yes, but my lord, as per your lordship, my FIR is not annexed in the petition, my lord. My verbal instruction, my lord.
Here is not there means what is not the same case number. Crime Branch PS case number 02 of 25.
25, yes.
Learned counsel for the petitioner and learned additional PP. Report as called for from the IO has been received, wherein it has been stated that the concerned mobile phones were sent to FSL Kahilipara for obtaining scientific examination and for obtaining expert opinion, and the said exhibits along with FSL report have been received from FSL Kahilipara on 24/12/2025. Full stop. It is further stated that the court may release the aforementioned seized mobile phones in Jimma of the petitioners Full stop. Having regard to the above, it is directed that the aforesaid mobile phones, namely, you take the from the C petitions, okay? Is there in this report also?
That report may kindly kept as a part of the record, my lord.
Released the custody of the petitioner. Very proper verification of the identity. The petitioner. Further, provided that the petitioner shall use the aforesaid mobile phones before the IO oblique court as and when directed. The report of the IO dated 8/1/2026 kept as part of the record. The criminal petition stands disposed of according.
Obliged.
Thank you.
Please, Your Lordship. Here is a partial petition file before it. Whereby the FIR is at page number 97, my lord.
In this case, earlier case diary was called for, my lord, case diary not received, my lord.
Service on respondent number 2 is complete now.
Completed, my lord.
What is the case? Should we appoint an amicus?
No.
Not necessary, is it?
Yes, to-
What is the case?
yes,
The
to-
case is about, my lord, the allegation in the FIR is that, my lord, that informant has alleged that we have siphoned some money to our companies. And there were some business dealings, and it's a pure civil case, my lord, because they have filed a civil suit as well, my lord, for the civil code. For that, my lord,
But
my lord,
CD is also, is the CD
Payroll-
here?
No, my lord, CD not received.
Service on respondent number 2 is complete. However, none appears. CD as called for has not been received. Issue reminder, release the matter again on
On, my lord, 25/2, my lord. (25/2).
Yeah, please. My lord, in this case, we are led by senior counsel, Mr. Z. Kamar, my lord. And he is led on another court, my lord. Kindly take up it too, my lord.
I'm attending to respondent number 2. I pray this. And in the meantime, we'll file our affidavit in reply in the case.
the prayer of learned counsel appearing for respondent number 2. Is the matter again on given date. Respondent may file their counter in the meantime.
Continue.
Right. 21 and 22. 21 and 22.
Lordship may take up the matter 22 first, my lord.
PCR is received.
Here received, my lord.
I have taken steps, my lord. The respondent also appears, my lord.
We'll file our objection, Lordship.
PCR is not received.
Here received, my lord. From the
You heard learned counsel for the petitioner.
My lord, may I make one submission, my lord? The next date is on 16/1, my lord. I have made a stay prayer, my lord. Well, here, my lord, only two things, my lord. Lordship may kindly see, my lord. 61/2, my lord, the criminal conspiracy is there.
the criminal conspiracy is of 2 or more persons, that will not attract, my lord. And secondly, my lord, the criminal breach of trust and cheating, my lord. So those two sections cannot coexist, my lord.
(16E1) has been fixed for what?
For appearance, my lord.
You're on pre-arrest bail.
My lord.
You're on pre-arrest bail.
No, my lord. This is a criminal petition, my lord. I am on bail, my lord.
That is what I'm saying.
Yes, my lord. I am on bail, my lord.
So we can wait.
May I stay the proceeding, my lord?
No, let them file their counter since you are protected.
Protected, that's true, my lord.
Heard Mr. and the Dr. Learned Counsel for the petition learned additional PP. So and so has entered appearance on behalf of respondent number 2 and prays for time to file objection. TCRS call for has been received. Release the matter again on so and so.
Second week of February.
Well, if your lordship doesn't give my lord stay, then my lord, can it be on my lord 28 or 29 of this month, my lord?
Anyway, I think after 16th date will be fixed after 1.5 months there.
Yes, my lord, 16, my lord, then maybe 1 month, 16 February. 2nd of February, my lord. 2nd of February.
No, what is the difficulty with 16th?
Same order, my lord, 21 and 22.
God bless us.
May it please your lordship, in this case, the appellants were convicted and sentenced under section 304, part 2, for a period of 7 years each. We have taken steps, your lordship, upon the respondent number 2. As per the office note, your lordship, the AD card nor notice has been received back. 7/1/2026, your lordship.
Any objection filed by prosecution?
That has not filed.
AD card in respect of respondent number 2 has not been received back. No objection has yet been filed by prosecution. Is the matter again on? And so in the meantime, prosecution file their objection, if any. List again on.
March, January till last loan together. January last of the
3130.
Deep your place, your lordship. 30.
May I please your lordship? Lordship, here in this case, lordship, the petitioner was arrested on 3rd of September 2025. As on date, lordship, he has completed 120 days. This is a charge sheeted case, lordship. Here, lordship, the prime ground on which, lordship, I am seeking bail is that, lordship, the petitioner was arrested on the basis of the co-accused statement. Nothing was recovered. The prime accused was arrested on 15/7/2025, and thereafter this present petitioner was arrested on 3rd of September after 1.5 months. FIR, lordship, is at page number 19, lordship. Let me kindly come to the FIR, page number 19.
Charges framed.
Yes, lordship. Page number 19, last paragraph.
That means we must presume there is some material against you. So without seeing the.
They have filed their discharge petition also. Discharge also rejected, my lord.
Then.
Here, lordship.
We'll wait for the CD.
My lord.
We'll wait for the CD.
Lordship, TCR has been received, lordship.
Received.
TCR received, my lord.
Updated, I think. Updated.
Only updated.
Updated, lordship. Check.
No, my lord. Here, Not up to date, my lord. 17 up to search PM, that order is there, my lord.
That was the
After
last order.
search PM, my lord. And evidence, that was, first it was for evidence, additional evidence 12.
Dear Lordship, my ground is that, Lordship, apart from the co-accused statements, Lordship, in as much as 7 witnesses are there, Lordship, apart from the statement of the co-accused, Lordship, if anything is there, Lordship, if anything, a single line is there, Lordship, then my bail petition may be rejected.
My lord, next date was fixed on 12/12/2025 for evidence, my lord. That part is not here, my lord.
Only
Whether,
one date.
any witness examined or not, my lord. Here, Lordship may kindly produce, my lord, huge amount of contraventions were recovered, my lord.
Bottle of cough syrup.
Cough syrup, my lord. But they have, in their statement, it is said that they have passes, my lord.
Discharge order is, rejection order is there.
Yes, Lordship. My lord, I have filed one additional affidavit at page number 41.
What is the date of discharge order?
29/11/2025.
29.
29/11. Additional affidavit, Annexer A, page number 41.
Page?
Page number 41.
Additional affidavit.
Yes, Lordship. Third paragraph, upon going through the case record carefully, particularly the statement of the accused, Minal Haq, that is the prime accused, it appears that there are sufficient implication as far as the involvement of the accused, Sekandar Ali, is concerned, that is the present petitioner. Thus, I am not inclined to discharge him from the instant case. Accordingly, instant discharge petition shall be rejected.
So what, apart from that, any other material is there?
Nothing, Lordship. I have gone through the entire LCR, Lordship, PCR, Lordship, even Lordship, copies were supplied to us. Nothing, even Lordship, the Caesar witness, even Lordship, the statement of the informant also. My name is not there.
You want to see the records again? No,
My
just
lord,
in.
my lord, I have gone through the record, my lord. Here, also, my lord, 181 statement of the accused, 180 statement of the accused, I have not found it.
His statement was not recorded, Lordship. 180 statement was not recorded of the.
Whatever that is, my lord, it was, my lord, huge quantity, my lord, commercial quantity, my lord. And during the investigation, my lord, it has led to the, my lord, from the statement of the accused person, arrested accused person, it reveals that there was purchased from the accused present petitioner, my lord. That's why there is a investigation goes on this way, my lord. And search also frame, my lord. He was not discharged, my lord, after going to the materials, my lord. Lordship, at this stage, some of the witness, vital witness may be examined, my lord. Without the examination, it will be, my lord, not fair, my lord. And last 12/12, my lord, here, whether witness was examined or not, that information is also not here, my lord.
No, witness cannot say anything beyond what is there in the record.
But IO is there also, my IO may also may.
What will IO say?
And it is that 37 records of 37 will come, my lord.
As far as 37 is concerned, Lordship, I am relying on certain judgment, Lordship. One of these, Lordship, is PA number 3398 of 2025, order dated 17/11/2025, Lordship. Here, Lordship, relying on.
What is the implication by the co-accused that it was purchased from him?
My lord, huge quantity, my lord, 39 bottles of cough syrup, my lord.
Was purchased from him.
Purchased from him. And when they went to sold the, my lord, that retail seller, they said that I purchased from him and sold it in the retail, my lord. Then police apprehended. There is a serious allegation, my lord, against him, my lord.
Allegation may be serious, but what is the material other than statement of co-accused?
My lord, so far as the statement of the co-accused lordship, one line I am reading lordship. মোর ভরির বিক আরম্ভ হওয়াত মই কাপ সিরাপ কিনে আনার দায়িত্ব মোহাম্মদ সিকেন্দার আলীক দিও। That is the statement of the co-accused. He has not said that he has purchased these things from me. He said that he has given the responsibility of purchasing things to me. This is the statement, lordship.
There's a statement, my lord, here. I have also clicked my
Yes.
in the LCM.
180 statement, only one line.
Only heard learned counsel for the petitioner and learned additional PP. There is an application for bail on behalf of counsel. Paragraph 3. Petition. In the meantime, the investigation has been completed and charge sheets has also been submitted. The learned trial court has framed charges against the accused persons, including the petitioner, after rejecting a discharge application by an order dated
2911. 29/11/2025, page number 41.
page
Page number 41, my lord.
order dated 29/11/25. The said order, it has been observed by the learned trial court that after going through the case record carefully, particularly the statement of the accused Minal Haq, it appears that there are sufficient implications as far as the involvement of the accused Sakendar Ali is concerned. Full stop. From the above, it appears that the learned trial court has relied upon the statement of the co-accused implicating the present petitioner to frame charges against the present accused. The TCRS called for has been received. Other than the aforesaid statement of the co-accused, no other material be pointed out by the prosecution. It is settled law that the statement of the co-accused cannot be taken into consideration for the purpose of at the stage of consideration of bail. Having regard to the above, without observing anything as to the quality of the evidence on record, the prayer for bail is allowed, keeping in view the provisions of section 37 of the NDPS Act. Full stop. Stated that it's no other material other than the statement of the co-accused implicating the present petitioner could be pointed out, the court is inclined to take the prima facie view that the petitioner may not be guilty of the offense involving possession / transportation of commercial quantity prohibited drugs. Accordingly, it is directed that the petitioner and so shall be released on bail of rupees 1 lakh with local sureties of like amount to the satisfaction of the learned trial court. Further provided that the petitioner shall regularly participate in trial and shall not try to intimidate or influence the witnesses in any manner. Petition stands disposed of accordingly.
Highly applies.
Please, your lordship. Lordship, we have some difficulty, lordship. Kindly, matter may be listed on 20th of January, lordship.
The prayer of learned counsel for the petitioner lists the matter on
20th of January.
22nd.
second.
Bless lordship.
No, listen. Petitioner before lordship is a government employee, and your lordship has already granted interim protection, interim bail.
Received.
Lamara.
Lamar.
Charge sheet submitted, my lord.
The charge is submitted under section 85, 89, and 92, my lord. And your lordship observed that, my lord, section 89 and 92 is not attacked. The session tribunal case not at your lordship. Send back him, my lord, and learned, my lord, SDGM may take custody, my lord. Your lordship may absolutely, madam.
Yes.
My lord, here charge sheet submitted, my lord, let him appear before the court below, my lord.
My lord, charge sheet was submitted under section 89, 92, my lord. The session tribunal, my lord. He may again take custody, man. And your lordship already observed that section 89 and 92 has not attacked, man. He's an interim, man. Your lordship, absolutely, madam, I'll face the trial, madam. Then tomorrow is the date, madam. Fix it.
Order dated 4/12/25. 1, 2, 3. Learned additional PP. The price that the charge sheet in the case has already been submitted by
Charge sheet number 45 of 2025, dated 11/12/25.
the under sections.
Section 89, 92, and 85, madam. And tomorrow is a fixed, madam, for appearance.
89, 92. The petitioner is a government. The sections under which the charge sheet has been submitted are sessions triable. In regard to the of the allegations, be necessary to remand the petitioner to custody. of interim pre-arrest bail dated is hereby made absolute. Provided that the petitioner shall not try to intimidate or influence the judges in any manner and regularly participate in the trial if one commences. Petition stands disposed of accordingly.
Diplo.
May I please your lordship? My lord, here affidavit CD was called for, my lord, that was not received, my lord, it was earlier rejected, my lord.
Lordship, as per my instruction, your lordship, charge sheet has been submitted, your lordship. And
What
your
the
lordship, special session case number 90 of 25 has been registered, your this one.
Number to assign, charge sheet number?
Charge sheet number, case number. Where is the date you fixed for your consideration of charge?
You call for the updated CD then.
Lordship, only charge sheet has been submitted.
per their
Trial has
updated-
started. Trial has started, your lordship.
Let's start it. Charges framed.
Today is fixed for your consideration of charge, your lordship.
Why do you say trial has started?
Today is fixed for consideration of charge, your lordship.
It's fixed, but whether charges have been framed, any information? It's 12:30 now.
Yes, they inform my lord, charges, I mean, let them appear, my lord, there.
He's in jail only.
Okay. Oh, then.
That is what I am saying. If
Fine.
today is for consideration of charge,
My lord.
if it takes place, after that the
My lord.
TCR we can have and
Fine.
consider. It is submitted that by learned counsel for the petitioner that charge sheet has been submitted and today is the date fixed for consideration of
Fine.
charge. Hence call for the scanned copy of the TCR. Please the matter again on.
My lord, 27, man, 27.
Obliged. May I please the lordship? Lordship, in this case, the petitioner is the wife of the informant, my lord. And the informant, my lord, earlier moved to petition before the trial court for releasing the petitioner, present petitioner, my lord. Allegation is that, my lord, the petitioner had some sexual relation with his own daughter, my lord, which is not at all correct, my lord. Lordships, may I kindly peruse the medical report, my lord. May I read the FIR first, my lord? That is at page 10, annexure B, my lord.
Name of informant has been shown.
My lord, here appeared, my lord. But one important thing, my lord, 183 statement of the victim, my lord. Our statement is not available. in the report.
I have annexed, my lord, in my petition, my lord.
Well, first let us see the FIR.
My lord.
Lordship, at page 10, my lord, annexure B. The suitor beg to state that the accused person is my husband. The accused person has been doing physical relation forcefully with my minor daughter, namely Shakshi Acharji, aged about 15 years. When he found her alone at home, when my daughter opposed, he threatened to kill her, for which reason my daughter refrained from informing me. This is the FIR, my lord. My lord, may I kindly peruse the statement that is I have annexed, my lord. That is annexure B, my lord, page 14. Married, my lord. My father Krishna Acharji has been doing bad thing with me for last 1 year. First time he has done the bad thing on 5th October 2024. Thereafter he started to do every month. Later on he started to do 2-3 times in a month. Bad things means by removing my clothes, touch my body. He insert his private part into my private part. On one day before yesterday, while I was not willing to stay alive,
Then the family members asked me about, accordingly, I informed them. This is the statement, Lord. My Lord, may kindly peruse the medical report. That is page 17. Relevant portion is at page 18, my Lord. May I read, my Lord? Paragraph 26, opinion, my Lord. Urine for BHCG is negative. Vaginal smear shows no spectromerism is seen in the vaginal smear. No evidence of any injury in her private part.
What is the date of examination?
My lord, that's
10/8/2025, just 2 days after the lodging the FIR, my lord.
So after 2 days after lodging the FIR, but what was the last time of
Right.
alleged incident?
my lord.
This incident is totally false, my lord, because, my lord, one Sujan Shah, who has manipulated this,
And according
this-
to you,
my lord, the FIR, the informant also stating the same thing, my lord. He has, lordship, kindly peruse the order dated 27, my lord. That is page 27. Last para, my lord. Seen the petition number so-and-so, filed under section so-and-so of BNS by Mampi Acharji, praying for granting of bail to the accused Krishna Acharji. Mampi Acharji, who is the informant, my lord. And this informant has filed one affidavit in this case, my lord, this present case, my lord, where she has specifically stated in paragraph 3, my lord. Merit, that the informant begs to state that
Whether you have filed this before the court? Whether
the
the court
informant
is
file. Informant file. This is the informant statement, my lord, I am reading.
It's not in.
Hmm?
One affidavit filed.
May I reading the FIR, that is the statement, my lord, what he has stated, my lord. Paragraph 3, my lord. That the informant begs to state that my husband Krishna Acharji is a e-risco driver and we have 3 daughters, namely Miss Kakul Acharji, is it about 17 years. Then Sakshi Acharji, is it about 15 years. Then Mansi Acharji, is it about 11 years. He has 3 daughters and he is it about 50 years, my lord, approximately 49 years. He has married 21 years back, it is stated. Acharji is about 20 years. 21 years has left of our marriage and there is no such incident as stated in the FIR with anyone till today. Informant saying, my lord.
Why it was
It is stated.
Why
It
it was
is,
filed?
that is the question, lord. That is Sujan Shah has manipulated, lord. Let me complete this paragraph, lord. It is stated that Sujan Shah has misguided the informant and by taking her signature without stating the fact and contents filed in the FIR dated so-and-so. And as such, if the Honorable Court grant regular bail to the accused, namely Krishna Acharji, she does not have any objection, my lord. If the informant is saying so, my lord, there is no
and
chance
what
of
about the
conviction. my lord.
victim? Is the victim also saying that Susan Chatterjee manipulated her into giving the statement?
Yes, Sujan Shah has manipulated, my lord.
For
Has
giving
the
the
victim said
statement
that?
under 183. before
Yes,
the
my lord,
court.
and that interesting, my lord, this child, my lord, this Sakshi Acharji is living with Sujan Shah at present also, my lord. The Sujan Shah has manipulated everything,
These
my
are the
lord.
matter of trial, my lord. Here, search frame on 5/12/2025 under section 64(1), 64(2)(m), and 65(1) of BNS and reduced section 6, my lord. Here, the next date is fiction 3012 for evidence, my lord. And her date of birth is 23/9/2010.
That is admitted, my lord.
Lordship, may kindly peruse her statement, one as it is not available, 180 statement, my lord. 180 statement is available. And father, his statement is, Lordship, may kindly peruse what he said, my lord. Father.
And as per the medical report also,
My lord.
you have given us the relevant pages
My lord.
18. But if you
The
come
17,
to
18, my lord.
17, hymen is ruptured.
My lord. That is
My
there.
lord.
My lord.
Anyway, let your affidavit come on record. Yeah, his affidavit. Learned counsel for the petitioner, learned additional PP. Mr. Swenso has entered appearance for the respondent number 2, and scanned copy of TCR has also been received. An additional affidavit has been filed on behalf of the, not additional, an affidavit has been filed on behalf of the respondent number 2, but the same is not on record. Registry is directed to place the said affidavit filed on
On fifth, my lord, it is, as per record.
5/1/25/26 on record. Is the matter again on?
Short date, my lord, is.
The month of February, man.
No, my lord, it's short date, 1/14.
But is the date fixed for evidence?
My lord, it was already over, my lord, 30/12/25, my lord.
My lord, on reopening, my lord, because
Date one
he is
to-
unnecessary behind the bar, my lord.
That one to statement witnesses may be examined,
No.
my lord. That is,
My lord, kindly short date, my lord. If the informant is stating that she has filed for releasing the petitioner, my lord, and if she is interested to release the petitioner on bail, my lord, there is no chance of conviction, my lord.
but victim is not yet examined, my lord. That is one thing, my lord. Whether victim is said on the same line, my lord, or not.
Short date, my lord, kindly be perused. On 20th, my lord,
In the
20th.
meantime, lordship may also
20th
call for
January.
appearance service, my lord.
Let the affidavit be come, in the short date, the evidence could not be taken.
No, evidence may have been taken.
The date is not, it is far, my lord. That is why on short date, my lord, kindly peruse the.
Also, okay, list also list on give the date. Also call for the record of the evidence recorded on 30/12/25, if any.
Fine.
Scan copy.
On 20th, my lord, 20th January.
Second, my lord.
22nd January. Lordship, diploma.
Please, your lordships. Lord, this is a 483 application, your lordships. Petitioner is behind the bar, your lordship. About 78 days, your lordship. There is a consensual relationship, love and love appears between the victim and the petitioner, your lordship. Now, they have no any objection. FIR is filed by one a village pradhan, your lordship, Gaambura, but not by his family members, your the victim's family member. FIR is, your lordship will find, page page 8, your lordships, in Varnical. May I read it? বিনীত নিবেদন এই যে মই বৰকা গাঁৱৰ গাঁও প্ৰধান হওঁ, ওৱান গাঁও প্ৰধান your lordship, বৰকা গাঁৱৰে শ্ৰী বাসৱ ডেকাৰ ছোৱালী বৃষ্টি ডেকাৰ বয়স 16 বছৰ গা অসুস্থ হোৱাৰ বাবে যোৱা ইংৰাজী 19/10/25 তাৰিখে ৰাতি 12 মান বজাত চাংচাৰী এইমছ হস্পিটেললৈ চিকিৎসাৰ বাবে যোৱাত চিকিৎসকে তাইক গৰ্ভৱতী বুলি জানিব দিয়ে আৰু আজি 20/10/25 তাৰিখে ৰাতিপুৱা প্ৰায় 12:15 মান বজাত তাইৰ গৰ্ভৰ পৰা এটি শিশু জন্ম হয় বুলি জানিব পাৰোঁ। তাইক সোধাত তাই জনায় যে পদকীয়াই তাইৰ ঘৰত তাইৰ লগত শাৰীৰিক সম্পৰ্ক কৰিছিল। দৃষ্টি ডেকাৰ ঘৰৰ মানুহ অসুস্থ হৈ থকাৰ বাবে মই গাঁও প্ৰধান হিচাপে আপোনাৰ থানাত এজাহাৰ দাখিল কৰিলোঁ। গতিকে মহোদয়ে পদকীয়াৰ ওচৰত আইনমতে বিহিত ব্যৱস্থা লয়। The FIR was filed by the one Gaon Pradhan, your lordship, not his family, not our family members, your lordship. So now he is behind the bar now 78 days, your lordship. So they have no any complaint regarding the petitioner, your lordship. Now they are live together, your lordship, in the house of the parents, your lordship.
My lord, POSCO is there
So-
regarding service of
Service
notice.
completion.
Service report, as per my instruction, my lord. Service completed, my lord, in this case.
CDB retained.
33.
Here in this case, I have filed one additional affidavit, so that is not on record. So may I pray that this matter will be fixed on immediately after reopening, Lordship, along with that
It is
affidavit.
submitted on behalf of the petitioner that an additional affidavit has been filed on
On 7/1/26.
7/1/26. Registry is directed to take the same along with the record and list the matter again on
22-1.
Problem. Case diary is here, Lordship.
CD received be retained till then. Is it?
Well, if required, I will send back again, I will get it, my lord.
In that
If
case, Lordship,
necessary,
in
but
that
it may
case,
not be
Lordship may
recorded
fix a
since
slot date,
it may
Lordship.
be-
It will not record anything.
Obliged.
May I please your lordship? Allegation is that based on the reliable information, police team conducted a nakasek in highway and recovered 15 kg of ganja and immediately apprehended 3 co-accused. Lordship. And the allegation on the petition, present petitioner is that page number 16, kindly have a look, Lordship.
Received.
My lord,
CC or
my lord,
call for any
the
process.
last occasion, my lord, there is some, my lord, order, my lord, in the last order, Lordship, may kindly please, my lord. Here, scan copy of TCR was called.
It was supposed to
But
be
it was
It is not charge sheeted.
not yet charged.
I have checked the TCR, Lordship.
There is the-
Charge sheet
But
has
then
not
it will
been
not
filed.
have CD.
My lord, CD is not here, my lord.
He was arrested on 15/11, Lordship. As on today, 54 days, Lordship. Registered under 20B, Lordship. 20B supposed. 60 days offense, Lordship. State of period is 60 days, Lordship.
Sixteen 11.
15/11. But record shows this, it was, he was arrested on 16/11.
So not even 2 months.
My lord.
54 days, Lordship. Kindly maybe consider that. And kindly have a look at page number 6 of my 5 of my petition, para number 7, Lordship. I have stated all things, Lordship. I am a e-rickshaw driver, Lordship.
All of them e-rickshaw.
Drives manual rickshaws now and
Arrested,
everybody drives e-rickshaws only.
In the earlier case also e-rickshaw.
Very convenient.
The apprehended accused were arrested from the spot, Lordship.
matter of fact,
They were
yeah.
released on bail, Lordship.
Day after tomorrow, my lord, we will try, my lord.
And in the meantime, during the Bihu vacation, Lordship, he will complete 60 days, Lordship. It will be not possible, Lordship. Kindly consider the length of detention, Lordship, at this Lord. My humble prayer for your Lordship.
But can you take instruction if
My lord, whether charge sheet submitted.
charge sheet has been submitted?
My lord.
Kindly fix it two, Lordship. LCR itself showing that, Lordship, charge sheet has not been submitted, Lordship. If it is submitted, it will come tag with the record.
This was sent on 24/12, so
My
that
lord.
may have been submitted thereafter.
I'll take instruction.
TCR, scan copy of TCR has been received, but CD is not received as none was called for. Learned additional PP 6 time to take instruction as to whether charge sheet has already been submitted. Hence, list the matter again on
Last day.
all right tomorrow.
Nice, Lord. Please, Your Lordship.
My lord, POXO is there, notice was issued to respondent number 2 and office note.
May I please, Your Lordship?
You want number, I think?
Did he receive?
$75 case diary not received, my lord. As per my instruction, my lord, search sheet submitted in this case.
Yes, Your Lordship. Your Lordship, on 36 notice, there is no signature of any witness, Your Lordship. Your Lordship, guidelines given in K. Basu for the state of West Bengal, Your Lordship. Signature on the arrest memo is mandatory, Your Lordship. It is in additional affidavit, page number 12, Your Lordship. ¿Qué pasó?
Per my instruction, search sheet not.
Your Lordship, in a similar case, Your Lordship, this honorable court in BA 386/25, Your Lordship, this honorable court gave bail, Your Lordship, to the petitioner because there was no signature in the arrest memo, Your Lordship. Over section 62 of BNSS, Your Lordship, may I read it, Your Lordship? Section 36.
Your signature is there in arrest memo.
Your Lordship, independent witness, Your Lordship. Witness.
Yes, but which part are you relying on?
Regarding that aspect, my instruction is today only is that search sheet submitted. Regarding that, my lord, he wants to argue on that aspect, my lord. I will have to, my lord, get the records of the, my lord, TCR. Then I will have to compare the, my lord, submitted, and I will have to give my own argument, my lord, regarding that.
Your Lordship, it has been 205 days, Your Lordship, behind the bars, Your Lordship. Moreover, Your Lordship, charge sheet was filed on 9 of December 2025, Your Lordship. On 14th of December, it would be 180 days, Your Lordship, for behind the bars of the petitioner. And on the 8th, Your Lordship, Your Lordship, on 8th of December, Your Lordship, the investigation officer have asked for 3 months, Your Lordship, for extension of the filing of charge sheet, Your Lordship.
Copy of the additional affidavit is also not with us, my.
Your Lordship, on the last date, it was available with the 100 PP, Your Lordship.
No, this is regarding statutory period. Is it complete?
Your Lordship, it would be on 14th of December, it would be 180 days, Your Lordship. But what the investigation is official.
14th of December.
Yes, Your Lordship.
The charge sheet was submitted before that.
Before
Yes,
that.
9/12, well, on
8/12, IO has asked for 3-month extension, Your Lordship. It was rejected on 8/12, and next day charge sheet was filed. 3 months work IO did in 24 hours, sorry, Your Lordship.
For going into all those details, I will have to check.
No, but charge sheet has been filed.
Has been filed, Your Lordship.
Question of statutory period is no longer available
It's
now.
there, Your Lordship, but this,
All right, we can have the TCR immediately on
Yes, yes.
reopening. Stated that charge sheet has already been submitted by CS number.
398/25 dated 9/12/25.
Call for the scanned copy of the TCR along with CD. List again on
28.
22nd.
22nd one, yes.
May it please the Lordship. In this matter, the petitioner is seeking bail on mainly on the ground of violation of Article 22(2) of the Constitution, my lord, whereby he was not produced before the Honorable Court, remand court, within a period of 24 hours, my lord. But before going to this aspect, my lord, just briefly place the facts, my lord, associated with this case, my lord. May I just, my lord?
I think this will take some time.
Yes, my lord, it will take.
Let's
my
have
lord.
it up to.
Oh, let's- From my custody, my lord, they seized this document, the material, my lord, one Mahindra vehicle bearing number so and so, one Eco vehicle and passbook, Aadhaar card and driving license. So at about 3:30 AM, my lord, I was detained by the police officials. And on the next day, my lord, on 21/4/2025, 25, my lord, at about 11 PM, as per the 47 notice, my lord, for 11 PM on the same day, my lord, at night of 11 PM, I was arrested, my lord. I was officially arrested.
Where, what are you referring to?
My lord, 47 notices not there. If I have the certificate copy, may I just place before your lordship, my lord?
Hmm.
11, yes, my lord. Certified copy I have, my lord. That 47 notice. 21/4. That is a 47 notice, my lord. Down below it is.
11:30.
Yes, my lord. 21/04/2025. It is there, man. And my lord, on the next day, 48 notice was issued to my relative, my lord, which I have brought before this honorable court by an additional affidavit. Lordship will find there, my lord, that that notice was served by the police personnel at 11:30 AM, 22/04/2025. Lordship has got it, my lord. That 11:30 AM, my lord, 22. The affidavit page.
All right, 47 is his arrest. 48.
Yes, my dear. 48 was served to me,
May not be-
served to my family members on.
That may be after that also.
Yes, madam. 22/04/2025 at 11:30 AM. Now, my lord, as per the diary entries, my lord, at 22/04/2025, my lord, at 2:30 PM, I was produced before the honorable court.
On
22/04/2025 at 2:30 PM. That a flag mark, my lordship will definitely find. Two 30 PM, my lord. I was produced before the remand court. So
This we get from where?
from the case diary, my lord, that is there. It was requisitioned.
All right.
So my humble submission is that the moment a person's liberty is curtailed, my lord,
Place of arrest is?
Badharpur, my lord.
Badharpur PS, my lord.
They have taken them to Karimganj, my lord.
Yes.
Yes, my case is that when a person's liberty is curtailed, my lord, that very moment, my lord, the Article 22(2) comes into force, my lord.
What is that time?
That is 3:30 AM, my lord. It is admitted, my lord, because from 3:30 AM, I was under the effective custody of the police personnel, my lord.
3:30 AM on which date?
21/04/2025, my lord.
3:30 PM.
AM, my lord, AM. It is AM.
That means that is before this 47 notice.
Yes, my lord. Because, my lord, it is the time of detention, my lord. But
Where do we get that?
That time, my lord, I have annexed in the from the seizure memo itself, my lord. The seizure memo reflects that time of seizure, my lord. From the very time, from that very time, my lord, I was in the effective custody of the police personnel.
Seizure list is 3:30 AM.
AM, yes, my lord.
AM.
AM.
On 21.
21, my lord. My lord, entire day, they could have, my lord, they have the time, my lord, to produce me before the court because I was apprehended by them in the early hours of that morning, my lord.
But how can we, where from do we get that? That is the time of the seizure list.
Yes, my lord.
The seizure was made at that time.
Yes.
But what was seized at that time?
That lordship kindly.
Not contraband.
No contraband, nothing, my lord, nothing.
All vehicles were seized.
Only vehicles.
But how can you say that that is synonymous with the period of detention?
But I have
That he is under detention since then.
But because I am submitting, my lord, the moment a person's, my lord, free movement is curtailed.
No, where do we get that his free movement is curtailed?
I'll rely some of the judgments, my lord, probably.
We are not going to judgments now. We are going to the facts now. Where from can you show that this free movement was curtailed from 3:30 AM on 21/4/25?
Yes, my lord. My lord, to buttress
Except
that,
other than the seizure list. Seizure list does not say that he has been detained.
I will take your lordship to page 59 and 64, annexure 6 of my bail application. That is Karimganj PS case number 192 of 2020. Page 59, my lord. Page 59. What happened in this case, my lord, there was another FIR against the present petitioner and his family members, stating that, my lord, that when they went to my house to apprehend me, I resisted the arrest, and family members made also some kind of hue and cry, my lord. Page 61 is the FIR, 62 is the FIR, lordship, filed by one sub-inspector of police, my lord. So this FIR, my lord, clearly fortifies that from that very moment, my lord, I was in the effective custody of the police officials, my lord.
Present police PS case is what?
Present police case is, my lord, it's Badharpur PS case number 76 of 25. When they went to my house in
Badharpur PS
76 of 25. When they went to my house, my lord, to apprehend me, they said that I resisted the arrest, and my family members also made hue and cry. So, my lord, that FIR was lost, and their lordship will get the timings, my lord. Which, my lord, clearly in consonance with the Caesar memo prepared at Annexure 7, my lord. That record also Rothschild has called for, my lord. That is also there.
Yes.
That charge sheet, that case, my lord, which I have just referred, my lord, that is also charge sheeted, my lord, and records are also there, but I'll place the certified copy of the charge sheet, my lord. There also Lordship will get the details of the timing, my lord, in relation to apprehension of the present accused.
It's the same thing.
Yes, my lord, that's it. There also the prosecution stated that my lord acted on that day at about 3 a.m. after reaching the residence of aforesaid accused person. Then he Shardul Tapadar so and so. So my lord, effectively, my lord. So these documents, my lord, effectively shows that I am in the custody. I have been apprehended at about 3:30 a.m. on 21/04/2025, my lord. And from the records, my lord, on the night of 21/04/2025 at 11:30 p.m., I was formally arrested, my lord. And on the very next day, at about 2:30 p.m., I was produced before the learned remand court, my lord. So if Lordship calculates this period, my lord, that exactly comes there about, my lord, 35 hours. 35 hours, my lord. And one aspect, my lord, senior has pointed out, representing the state, that what time is required, my lord. From the Badarpur police station to the remand court, my lord, as per the Google map, it is only 23 kilometers, 700 meters. And the travel time requires is 30 to 45 minutes. That can be verified, my lord. So even if we exclude, my lord, that time also, that also, my lord, do not help the state, my lord, to argue that he was not produced. He was produced within a period of 24 hours, my lord, as mandated by section article 22(2) of the 2, my lord.
So according to you, the 24-hour period expires at around say 4:30 or 5
Yes, my lord.
in the morning of 22nd.
Yes, my lord. And I was produced, my lord, before the Honorable Remand Court at 2:30 p.m. That, my lord, that is a documented document, my lord, from prosecution's document whereupon I am relying, my lord. That is also part of that record, my lord.
Yes.
Yes, my lord, in that aspect, in that regard, my lord, I am relying to decisions, my lord, as handled by COVID. Yes. My lord, paragraph 5 is very important, where the time has been elaborated, my lord. Lordship, there is a Supreme Court judgment, my lord, why this paragraph 5, my lord. The submission of the learned counsel appearing for the appellant, Lordship has got it, my lord. The submission of the learned counsel appearing for the appearing for the appellant is that pursuant to lookout circular issued against the respondent, he was detained at IGI airport from 1100 hours on 5th of March 2022. But he was shown arrested on 0105 hours, 0115 hours on 6th of March 22 by the Appellate Enforcement Directorate and was produced before the court of the learned magistrate within 24 hours from 115 hours of 6th March 2025. This argument cannot be accepted. Admittedly, the LOC was issued at the instance of the Appellate Directorate of Enforcement. By executing the LOC, the Bureau of Immigration detained the respondent at IGI airport from 4th of March 22 on behalf of the appellant. The finding of fact recorded in paragraph 10 is that undisputedly the physical custody of the respondent was taken over by the appellant from the Bureau of Immigration at 1100 hours of 5th of March 22. Thereafter, at 115 hours on 6th of March 22, an arrest memo was prepared by ED at Raipur. He was produced before the court at 3 p.m. on 6th of March 2024. The perusal of the arrest order shows that typed order copy was kept ready. The date and time of arrest were kept blank, which appeared to have been filled in by hand. Admittedly, the respondent was not produced before the nearest learned magistrate within 24 hours from 11 a.m. on 5th of March 2022.
Yes, all right. We have
Yes,
no difficulty, nobody disagrees with that. So, there is no disagreement with regard to this finding. We have seen this already.
Yes, ma'am. And but next, matter, it is of Honorable Guwahati High Court, which was passed on 12/12/2025. That relevant paragraph is, my lord, paragraph 11 and 12, ma'am. That is very recently, my lord, our Honorable Guwahati High Court granted bail on that exact point, my lord. Yeah. May I just read, my lord, paragraph 11 and 12?
Yes, we have understood. All right. We'll read in leisure. Got the points.
There are other judgments also. If Lordship permits, may I just place those, my lord?
Why burden the court with 100 judgments when one will do?
So, in my respectful submission, my lord, the petitioner is entitled for bail on this count, my lord, as he was not admittedly produced before the Honorable Remand Court, my lord, within a period of 24 hours, my lord.
All right.
Yes, prosecution.
I would just like to, my lord, point out one thing, my lord. Regarding, my lord, mere apprehension or detention does not amount to arrest. Right now, the judgment shown by my learned friend, Your Lordship. Your Lordship, I would just like to point out one line, my lord. Yes, regarding that aspect, my lord, within 24 hours, the accused person was not produced, my lord, for which bail was granted. There is no dispute on that, my lord. But regarding that aspect, my lord, here in this case also, petitioner was detained in airport on, my lord, 4/3/2022 at 18 hours, at 6 p.m., my lord. And here, Your Lordship may kindly come to page 2, my lord. 1, 2, 5, 6, 6 line, my lord.
Which paragraph?
Paragraph, my lord, that is
Of the judgment?
Of the judgment.
Which one? Supreme Court?
Of this now cited by my learned.
That is one, my lord, the Director of Enforcement versus.
Yes.
Yes.
Just trying to pointing out that my lord, mere apprehension or detention does not amount to my lord arrest. Because from that judgment, your lordship may kindly see from the first line, when petitioner was detained on 4/3/22, 6 p.m. 4/3/22, 6 p.m. And thereafter, your lordship may kindly come to regarding dispute of production him within 24 days. I am not disputing that. I am
Yes,
just-
he was detained at IGI airport
Yes,
from 1100
on
hours
detention may not amount to arrest. I am
on
just
5th March.
4th March, my lord.
Not 4th March, 5th March.
No, your lordship may kindly come.
Para 5.
Para 4, your lordship may first come to para 4, my lord. From the documents available in the case diary, the aforesaid order, it is crystal clear that the applicant was detained and taken into custody at 18 hours, 6 p.m. on 4/3/22 at IGI airport, my lord. So he
Even
was
earlier.
detained at 4/3/22 on that day. Thereafter, your lordship may kindly come to page 2, my lord, 1, 2, 3, 4, 5, 6 line, my lord, admittedly, thereafter, my lord. Admittedly, the respondent was not produced before the nearest learned magistrate within 24 hours from 11 a.m. on 5th March. So from when date was calculated? From 11 a.m. 5th March. So and when he was detained on 4th March, my lord, 6 p.m. So, my lord, although he was the mere, I am just trying to point out mere detention does not amount to arrest. So here, my lord, admittedly, the respondent was not produced before a learned magistrate within 24 hours from 11, within 24 hours from 11 on 5th. So time was calculated from 11 a.m. my lord, 5th March.
That is when custody was handed over to the ED.
Yes, when custody was handed over to the ED. Only because he was merely apprehended on, my lord, 4th of March, my lord, 4/22, my lord.
Here the custody was, in this case, the custody was with you all along.
Yes, my lord. Here, my lord.
So where from will you calculate the time?
Here also I will point out regarding that aspect. My argument is that mere apprehension or detention does not amount to arrest, my lord. Only when, my lord, police has my lord, when police formally arrested, only thereafter, my lord, these periods counted, my lord. And here, for when police formally arrested, my lord, by showing that Caesar list, my lord, your lordship, Caesar list of, my lord, 21/4/25 at 3:30 am.
Yes.
From whom, my lord, sees Sanjul Haq Tapadar. Probably, my lord, he is the owner of he is probably brother of the present accused, not the present accused, my lord.
Present accused is named?
Sharjul Haq Tapadar.
Sanjul Haq Tapadar. So, my lord,
Caesar list in respect of whom?
Sharjul Haq Tapadar.
Sanjul Haq Tapadar. Sanjul, not the present petitioner. My lord. He is the vehicle is in the name of the, my lord, present brother of the present petitioner, my lord.
And who is named in this?
The
Page 62.
accused person is the present petitioner, my lord. He is the accused.
I was apprehended, my lord.
But regarding the Caesar list, my lord, that vehicle was seized from his brother. And vehicle, the owner of the vehicle is the brother of the present accused person, my lord. So, my lord, thereafter, my lord, on that only because merely, suppose, my lord, he was only because he was merely apprehended, my lord, although not apprehended, my lord, my argument. Then, my lord, where 47 notice, my lord, especially he was shown arrested on, my lord, formally arrested on 21/4/25 at 11 p.m. So, on record, my lord, he was the present petitioner was formally arrested on 21/4/25 11 p.m. But regarding in the 48 notice, my lord, they have annexed, my lord, it is shown as 22/4. So, my lord, regarding that, my lord, I have some confusion. But in fact, my lord, from record also, it is on 21/4/25 11 p.m.
11.
The additional affidavit they have, my lord, now the 48 notice they have annexed. Therein it is, my lord, appeared that date of arrest is 22/4/25 11 p.m. But in fact, on record also 21/4/25 11 p.m. Thereafter, on 21/4/25 11 p.m., admittedly he was arrested. From thereafter, from Badorpur, my lord, he was thereafter, my lord, produced before the learned trial court. Learned trial court have also passed, my lord, remand order. At that point of time, none of these grounds, my lord, raised. At 2:30 p.m., my lord, suppose, my lord, why I wanted detail, because suppose, my lord, on that day, my lord, or at about 10 p.m. court sitting hour of the court from 10:30, suppose the accused person was taken to the court by the police, my lord. Then suppose order was passed at 2:30. Can it be said that, my lord, the accused person was not produced within 24 hours, my lord, before the trial court? within this period of 2 hours, can they take it a ground, my lord, that he was not produced before the trial court within 20 minutes? Suppose, my lord, on that day, because of urgent case from evidences, my lord, matter going on till 4 p.m. So court on thereafter, my lord, court can
No,
ask
let
the-
us go serially from where you have started.
Yes, ma'am.
Okay,
Yes, ma'am.
that 3:30 a.m. on 21/4/25, that appears from the page 62 FIR.
Yes, yes, my lord. That second FIR also is.
We
62.
ignored the seizure list.
Yes,
Yes, from
yes.
FIR
FIR 62, the second FIR.
In connection with same Badurpur PS case number 76 of 2025.
Yes.
Already check up if you like.
Yes, ma'am.
Check up after sometime or what tomorrow.
Same problem. My lord, it would be immediately after vacation, any date, my lord.
Too long.
21 or 22, my lord. Otherwise, from the record, my lord.
That's a very clear in that aspect.
And suppose if my lord 3:30, suppose as I'm accepting that their argument, police visited their house at 3:30 p.m. Seizure list is there at 3:30 a.m. My lord, Sanjul Haq Tapadar, my lord, police has seized the, because earlier police already arrested 2 accused persons. Maybe some information police has received from the 2 accused persons, thereafter visited their house. On that day, my lord, can it be said only because, my lord, for
All right,
some
21st.
preliminary inquiry
Yes.
for some, my lord,
When are we reopening?
19th, my lord.
22, my lord, 22, my lord.
22.
Thursday, my lord, it will be
20, let it be 20, my lord, kindly.
20, my lord.
Because the facts are already, my lord.
21.
Yes, yes.
In other case, Lordship, this is second time rejected, and in earlier rejection order, Lordship, that ground was taken that he was not produced within 24 hours. And the Lordship rejected because Lordship, that was during investigation stage, and the council could not show when he was produced before the magistrate. Now, Lordship, I have checked the record. Record shows that he was he was taken from the police station at 2:30 p.m. So even if we take that at 2:30 p.m. as production before the magistrate, then also, Lordship, it is 31 hours.
You will take that up together. You come prepared for both.
Yes, my lord.
And apart from 24 hours and merit also there, Lordship, that nothing was recovered from these persons, Lordship.
Can I have that 47? Can I have the 47 and charge sheet, my lord? I have just supplied. These are already part of the records, my lord.
That's all right.
Obliged, Lordship.
It's part of the record, then
Additionally
is
supplied.
the pagination.
Part of the
Trial court record, my lord.
You
I have
to
additionally
obtain
supplied.
certified copy from the, my lord. I have to obtain certified copy.
No, just now, my lord, I have supplied certified copies of 47 and 1 charge sheet. These are already.
They are in the PCR.
Yes, my lord.
All right. Mark that also. Okay.
47.
Had learned counsel for the petitioner at length. Learned additional PP Mr. P. Bhattakur 6. Time to submit his reply. For going through the case record. Cancel is the matter again on 21. Same order both. Next item also.
May please your lordships. Previous bail application lordships. This bail application lordships, it was filed on 23/7/2025, Lordship. Lordship, number of days, Lordships, fixed for CD, Lordships.
Not received, my
And Lordships also based on 24/11/25.
case
one
diary not
learned-
received, my lord. Amicus also appointed in this case.
Lordship, number of days, Lordships, fixed for CDs since July 2025.
Since July,
Lordships,
you're on interim.
Lordships, this FIR is at page 13, Lordships.
No, are you on interim?
No interim, Lordships. Lordship,
In
page-
case of next date, if case diary not produced, then I will needs.
There is this order of 6/11 itself. Which police station is this?
Portable Police Station. Corbata District.
Respondent number 2 has been served.
Yes. Amicus appointed, my lord.
Appointed. Learned Counsel Dixit Gogoi, Lordships. Even I served the copy also. On 24/11/20.
Pardon, Learned Counsel for the petitioner in Learned Additional PP. Service on respondent number 2 is already complete and amicus has been appointed. Appears that the IO has failed to produce the case diary since the month of July 2025. Despite directions issued by this court, particularly order dated 6/11/25 for production of the case diary, the same has not yet been made available by the IO. The officer in charge, Sottebari PS, is directed to ensure the production of the case diary by the next date fixed, failing which he shall appear personally to explain the failure to submit the said case diary. Communicate this, registry is directed to communicate this order to the officer in charge, Sottebari Police Station.
I am the amicus Kemal Times.
Is the matter again on? You did.
On my lord. 29/1, my lord.
William.
Receive. Did not receive list again on so and so. Interim order passed earlier to the. You're on interim, isn't it?
Earlier interim, we will get it. Much obliged.
Date of 29/8/1 release.
Please, Your Lordship. Can this matter be taken tomorrow, my lord? We have taken consent from respondent number 2, my lord. For tomorrow, my lord.
List again tomorrow on the prayer of Learned Counsel for the petition.
Tomorrow, my lord.
Please, your lordship. My lord, in this petition, your lordship was kind enough to grant interim bail. And the last order, my lord, it was submitted that the case has been transferred to CBI. And on 4/12/2025, my lord, it was directed that the case diary be produced.
Yes.
Please, Your Lordship. The case diary is very much here, but we have not yet received the copy of the petition.
Oh, we'll give you right now.
On the last occasion also, it was, our name was not reflected. Of course, this time name has come, but we need copy, then we can able to.
We're handing over right now.
Thank you. Yes, sir. Because it has been transferred to CBI for fresh investigation. That is why we need copy. If anything is there, we will give reply. Otherwise, appropriate order can be passed on the next date, Your Lordship. However, CD is very much here.
Heard Mr. M. K. Chaudhary, Learned Senior Counsel, assisted by Mr. T. N. Srinivasan. Learned Counsel for the petitioner. And M. Kumari submits that CD is available, but copy of the petition has not been served upon her. Learned Counsel for the petitioner has handed over the copy of the petition to Learned Standing Counsel CBI today itself. Learned Standing Counsel CBI therefore prays for time to file objection stroke reply. Allowed. Is the matter again on when?
You get confident.
After vacation, you will see.
Give a date after vacation. Interim order passed earlier shall continue till the next date of listing.
We will be requiring the new case number because they'll register a new case.
New case
immediately.
number will come, everything, all new formalities will start.
That will say in the next, on the next date.
We are only saying listing.
Next week,
Of license.
7-1. Oh. अच्छा, please.
किमान date है?
27-1.
Of license.
Yeah, please, your lordship. Kesari has been called for, matter has not been received.
Kesari not received, my lord.
We are on
It is
interim,
not
my lord.
received. Interim order passed earlier to continue. List again on.
In the month of February, my lord.
My lord. 4th of February, my lord.
Oblast, man. The interim order.
Item number 46, my lord, petitioner is in interim, my lord, CD received, but my lord, I have not found the statement of the petitioner in the.
But lordship statement I have given.
My lord, so
When I have appeared, I have given my statement.
get the instruction and update it.
It is lordship clear cut instruction. Even FIR is at page 17, it was just a allegation of suspicion of forgery of its signature. In the approval note of a claim case. Finally, the money was also not released and it was not settled just for the on a suspicion that somebody has and suspicion was made against the petition. I have sufficient ground to suspect.
Other than the statement recorded after interim protection, is there any other incriminating material?
But I will have. So CD is only up to interim granted on 27/11/25. CD is up to only 3/9/25 September. Up to 18/9.
18/9. D has been received, but statements of the petitioner said to have been recorded pursuant to interim order granted by this court are not available in the CD. Hence, call for the updated CD. List again on. Interim order passed earlier to continue till the next date of listing.
Deeply.
A2.
9.
CD received, my lord.
Yes, what is this about?
Lordship, the petitioner is falsely implicated in this case, Lordship.
Yes, PP.
I have received the case there, my lord. Lordship may kindly peruse the 183 statement, 182 statement, my lord. And thereafter medical report. Medical reported victim's claim, my lord. After medical report, my lord. Para 11, my lord.
Yes, any submission, counsel?
Not a fit case to grant him bail at this case, my lord. Sufficient materials are there against him, my lord.
Spencer Learned Counsel for the petitioner, additional PP. This is an application under Spencer. The CDS call for has been received. The allegation against the petitioner is that that when the victim had gone to search for her goat around the house of the petitioner, the petitioner gave vulgar indications to her, and when the victim tried to escape, the petitioner her to the ground. Destroyed her chastity. He also stated that the victim woke up in a state of shock and found herself bleeding, by which time the accused petitioner left the place. Where it is submitted on behalf of the petitioner that the petitioner has been falsely implicated. Perusal of the CD. The statement of the victim recorded under section 183 BNS as clearly implicates the petitioner having committed forcible sexual intercourse with the victim and her person, supported by the medical report. In view of the above, the present is not considered to be a fit case for grant of free arrest bail. Accordingly, the prayer for bail stands rejected. Send back the CD.
Please, your lordship. First, second application, my lord, earlier rejected. Up to date case diary was called for.
My lord, here, to receive the case there, my lord. Here earlier rejected, my lord. Lordship may kindly page the rejection order, my lord. At page 23, my lord. 11% is, my lord. Page 24 months. There are 5 minutes.
Updated CD means what are the material?
My lord,
Anything?
yes, my lord, here remains the same, my lord. All the accused persons are involved here, my lord, from the statement of the my lord, accused person, my lord, Mokbul Ali, Alam Ali, my lord. He hired some person, my lord, in the amount of 3 lakh and 95 lakhs or 95,000 already paid, my lord. Thereafter, my lord, all of the accused person planned for murder, my lord, and all of them contributed, my lord, amount for killing, my lord. And IO has collected, my lord, sufficient materials, my lord. Here, Lordship may kindly produce 1-2 statement, my lord. And there is a meeting among them, my lord, to contribute how he will be killed, my lord, how amount will be contributed, my lord. All the necessary accused person it is. And
Rafiqul Ali.
all of them, my lord, here, all of them, my lord, here. Against the allegation, my lord. Really killed, my lord. All, my lord. There's a meeting, my lord. Yeah.
All right, heard. Page 20.
My submission, my lord, whether all the accused person named Munna Ali Mojid Ali are there or not, my lord.
Your submission or is it your question? That has come before the question. Paragraphs, rest are all same. Paragraph 6, you write. In view of the disclosures made by the arrested accused persons, the real interrogation of the necessary is necessary to unearth the conspiracy, as well as the money trail. Will only be petitioners, it's petitioners 1 to 6. You delete. Send back the CD.
I'm the.
Enable those.
I don't know. As per my instruction, CS late in this
Hmm?
case. CS has been late in this case as per my instruction.
It is submitted by learned counsel for the petitioner that charge sheet has already been laid in the case, hence call for the scanned copy of the TCR along with CD. List again on.
Yeah, 3-2. 3-2, 3-2. Uh-huh. 3-2.
Received also.
This is a group clause between petitioner and informant, your lordship, regarding harvesting of a rice paddy in disputed land, your lordship. Lordship, in this incident, your lordship, the informant lost his son. Main accused was arrested, who caused the fatal injury, your lordship. Your lordship, one of the petitioner, number 2, Gola Bharali, also lost his finger, your lordship. We are the victim of the circumstances, your lordship. In the FIR, your lordship, against the petitioner number 1, Madan Bharali, and petitioner number 5, Pranab Pranay, there is no allegation was made. Lordship. We will cooperate with the investigation, your lordship. The main accused was arrested, your lordship. The civil suit was pending, is pending, your lordship. The informant lost the civil suit, your lordship, for recovery of possession, your lordship.
Five petitioners.
Yes, lordship.
Modern Golab, Zitu, Ratul and Pranab.
Pranab Saranya. In FIR, your lordship, petitioner number 1 and 5, there is no allegation.
As per CD lordship, these people along with one main accused was their lordship, Kandar probably lordship. Kobindra. All they have come, and when this the informant and their family members went for cutting the paddy field lordship, thereafter lordship, these people attacked them. All they have attacked him, and in that attack, one person died lordship. All have implicated injuries to them lordship.
FIR, your lordship, it is clearly stated.
Common intention is there.
And the witnesses have specifically mentioned their names. There are eyewitnesses also who have intentionally mentioned.
Also, the FIR, your lordship.
We have now passed the FIR. FIR we have seen.
Yes, lordship.
Beyond that also we have, other material has come.
Yes, lordship. Informant, your lordship himself witnessed the whole incident, but did not make any allegation against the Madan Bharali and Pranab Saranya, your lordship. And regarding this incident, Your Lordship, Gola Bhorali also, Your Honor, lost his one finger, Your Lordship. The main accused was arrested. In the FIR, Your Lordship clearly stated that the Kobindra Bhorali, Your Honor, caused the fatal injury, Your Lordship.
That has been caused. Cannot be so innocent.
Lordship, kindly petitioner number 1 and 5, Your Lordships.
Who is one?
1 and 5. Modern Bhorali and Pranab.
What is there against modern Varali?
Same lordship, all are same.
In concert.
When some one or two witnesses have also been injured, lordship, got injured.
Third learned counsel for the petitioner and learned additional PP. This is an application under so and so.
Cooperate, Your Lordships.
As per the what cooperation? Paragraph 3. The petitioner submitted that a whole story has been made out in the FIR. And there is dispute between them regarding land and the title suit is also pending between them. It is also submitted that an FIR was lodged by the wife of the petitioner number 1 of 12/11/25. Disregard Colasbury PS case number 284 of 25. Section 74/118 in bracket 2/3 within bracket 5 DNS was registered. On the other hand, PP with reference to the case diary has stated that there is sufficient incriminating material against all the present petitioners to attack the deceased and other members of the informant side in a concerted manner, which resulted in the death of the son of the informant. We are having regard to the material available in the CD and the gravity of the offense. The prayer for pre-arrest bail is rejected. Petition stands dismissed. The CD.
Your Lordship, I beg to state that my senior had to leave due to some personal difficulties.
We have received the CD. Lordship may dispose of it. Lordship may kindly go through 183 statement. No specific allegation of rape is there, Lordship, as per one.
Lordship, may please the matter be taken up tomorrow.
Learned counsel for the petitioner, learned additional PP decision application. Allegation. Yes, for the player. There are two. All four has been produced. Terracing the statement of the victim before the magistrate. Not find any incriminating material indicating commission of sexual intercourse. Having regard to the same. It is the view of the court that the custodial interrogation of the petitioner be necessary. Accordingly, the prayer for pre-arrest bail allowed. The petitioner so and so shall be bail of rupees 1,000. Security in the event of his arrest in connection with and disposed of. Yes, you have argued very well.
Much like you.
P455 POXO matter lordship notice and not served lordship. Right.
May I please, your lordships? This case, FIR in the page number, considered FIR page number 13, my lordships.
What to do is not served.
Can wait for some time lordship because.
Right. Service on respondent number 2 not yet complete. Okay, wait. List again on.
Kind of short date may be given, lordship.
Yes.
22nd.
54 and 55.
Yes. Hello.
We have received the CD lordship. CD may be written. Yeah, 54, 55 lordship. We have received the CD lordship.
CD already received.
55. CD to retain. CD received, retained till the next date. Yes.
May I please, in time is there, lordship. The matter, as a statement has also been recorded so far. One petition number 1 is concerned. Actually, main accused is also behind the bar, Sanjay Tamuli. So that account transferred to a brother's account and a mother's account. That case I also remember.
Time lordship because we have the CD. We see the CD lordships.
Learned additional PP submits that he requests further time to go through the CD. Prayer is allowed to list the matter again on interim order passed earlier to continue till the next date of listing.
29, Lordship.
There was a little bit confusion also. Can you see the order detail? No, it don't have a live one. Order is 12 and 25. Because both the petitions have been granted in time, that you will also kindly clarify. The order is 12, 11, 25. In para 6, you will also kindly see. Having regard to it is for event of arrest, the above named accused petitioner shall be allowed to go on bail. So the second petitioner, he has not gone before the court. Because you are also given reason that 60 years old in para number 5. Whether both of them are granted under that clarification also kindly give. Because in the condition petitioner it was given. So then the petition number 2 can also he can appear and record his statement. No petitioners was there, but in the condition only petitioner shall cooperate. That's why he has not gone. That will also allow him to go, he'll record his statement also in the meantime.
Instead of making clarifications today, the next date will say everything. What is that?
Whether he can appear before the IO, that's why I am asking Lordship. Because their arrest, there it is there. But in the condition only petitioner.
It is pointed out by learned counsel for the petitioner that in the order dated 12/11/25. It was provided that the accused petitioners shall be allowed to go on bail in the event of their arrest in connection with the present case, although it was observed in the same order that the petitioner number 1 is the mother of the main arrested accused, who is 60 years old and whose account has been operated by the main accused and seized, and she is ignorant of the deposit of any money in her account. Where it is clarified that the privilege of interim pre-arrest bail was granted only to the petitioner number 1 by the aforesaid order. What was the allegation against this?
Allegations are because one, the prime accused has been arrested, Lordship.
Against
So
two?
some account has been transferred to their account under Fishery Mission Society scheme. He has been arrested. He petition number 2's brother and petition number 1's son. His main accused is behind the bar. So some amount has been transferred to their account. That is the allegation.
That hasn't changed now.
That has
So we have clarified this only and will, so the rest will decide on the
Lordship. This is up to your Lordship.
finally.
Because I was under the impression only one was granted. That's why
Yes,
I pointed
yes.
it out.
So we have to send back the city for updation of.
Only one okay this year.
Baki diya na ito.
Who is not granted? Because I have heard it only one was granted. That's why I pointed out.
29.
29 next day.
Wait, please, Lordship. Lordship, as per office note dated 6/1/26, notice has been received back answer with postal remark insufficient address. Whereas, Lordship, in the maintained petition, same address is there. Flag X,
What is this maintenance?
yes, Lordship.
Husband, wife?
Yes, Lordship.
You are?
We have, I'm from the husband respondent. Here it is appellate petitioner. We have challenged the order.
What is the address?
In Lordship maintenance.
Resident of BBC Colony, Maligaon, Pandu.
Yes, Lordship.
Guwahati 12.
They have mentioned in their maintenance petition, and we send the address.
Where is he staying? Whose house is it? Parents' house.
Yeah, Lordship, I'm not aware of this. We have seen from this maintenance petition.
But you have to furnish the full address now. Ask your client to make inquiry.
So she is not with me, and we have no idea at the she is stay.
No, it only says insufficient address because there is no house number. I think it just says BBC Colony. It's a big area.
Lordship, it is in Annexure A. Lordship, kindly may see. The address is in the maintenance petition, and
Same.
yes, we sent in that in that address.
There is a mobile number also.
We have contacted, but there is no response from. Our call, Lordship.
It is in your interest to collect the address.
Okay, Lordship, we'll take fresh step again. We'll try, Lordship. There is an interim order, Lordship, and the interim may be continued.
As per office note, the notice issued upon the sole respondent has been received back, served with remark in quotation insufficient address, comma RTS. Petitioner is directed to furnish full address of the sole respondent and take steps accordingly. There is no interim, I think.
No, Lordship.
So it is in your interest.
Consider that.
Is the matter again on sense.
Hello.
Your Lordship. My Lord, as per office note dated 6th of January, my Lord. Service report is awaited, my Lord, in this case.
Service report in respondent number 2 not yet completed. I wait list again on.
Patient, my Lord.
What you want tomorrow?
Any date, Lordship, in the month of February. I am obliged, my Lord.
Lordship, this application is for correction of the order. Your Lordship, we have granted bail, Your Lordship. Paragraph 8, Your Lordship. In paragraph 9, Your Lordship, instead of land CJM, Your Lordship, the case is pending before the district and session judge Kachar, Your Lordship.
Paragraph?
Paragraph 9, Your Lordship. Lordship has granted bail, directed to furnish the bail bond, Your Lordship, with 2 sureties like amount to the satisfaction of.
Where is it pending?
It is pending before the district and session judge Kachar, Your Lordship. Charge sheeted case, Your Lordship, and pending for framing.
This IA has been preferred seeking correction of the order dated 5/1/26 in application 3941 of 25. Whereby at paragraph 9, it was the concerned court was mentioned as CJM Kachar, but case has already been committed, is pending before the learned session judge Kachar.
District and session judge.
The said order stands corrected, substituting the words CJM Kachar as Kachar. This order will form part of the order dated 05/01/26. Stands disposed of.
Obliging.
Because our part has been completed, my lord. This query was not there.
After vacation. Have you submitted any written
I have submitted judgment.
judgments,
Judgment.
but in any, no written argument?
No written.
Additional PP praise for adjournment. Hence fix the matter, you know.
20, my lord. Last 3 years he is in jail, my lord. Last 3 years he is in jail, my lord.
February?
Last part of January, my lord.
What will 5 days to do? 5 days.
Yes,
Little difference.
Pardon, my lord.
Pretty pardoned.
Yes, it's pardon, my lord. Pardon, my lord. Yes.
My lord, in this case, I am appearing for item number 62 and 63. And in 62, we have received the paper book and exhibits, but in 63, we did not receive the paper book. And this honorable court on the earlier occasion directed the section to give us the paper book, but yet we have not received. I have also personally visited the section and they received my phone number. Assure me to provide the
13 years.
as that paper book has not submitted yet.
In which one? 62?
63, 62 we have received.
We are on which item now? 60.
I am 62 and 63. In criminal appeal 383 we have received the paper book.
Let us say, Lordship, arising out of one judgment, there are this case 366, 347 and 383. That is 59, 60 and 63. This is arising out of one judgment. However, on conviction, 3 accused person file separate appeal. And then 363 and 382 arising out of one judgment, 2 appeal. And that is serial number 61 and 62. So 61 and 62 would be heard together and 59, 60 and 63 would be heard together.
Yes. Special case number 75, one is 75 of 2005. Another
Are
one
it
is
62 and
But
60?
all are arising out of the same judgment.
No,
No.
no.
Separate.
There are 2 sets of FIR. 2 person are common, Tapan Sen and Bedobrata Saikia. Common.
So in one set, paper book is ready and furnished.
Yes.
In the other set, paper book is not.
Yes, yes. In special case number 75, we have received the
My
paper.
submission is
Item
lordship
number-
that it is of 13 matter and paper book ought to have been taken earlier. They should have given the pair. Now on the garb of
But from
paper
the
book, again
section,
it is getting delay, 13 matter.
when I visited
And
to the section, in criminal appeal section, they received my phone number and assure me to give me the paper book. In item number 60.
And I suppose he had no communication to that effect. Madam has.
Nine. Then Tapon Sen. 13th, after filing of the case. I don't know about whether he's. That has to bring in.
Their appeal.
PA is to bring information about your client.
They are the best person, your lordship. I can. I don't have any.
Your Wakalatnama is still valid.
They are, but no taken with him.
What to do now?
And in that event, if there is any warrant, CBI will go and arrest. That is the solution. If no information with regard to death or alive.
We can only issue court notice then.
I'm appearing not for top.
So long counsel is representing.
This representing means counsel has to have effective communication for receiving instructions as well. Okay, give me the case number where you do not have the paper book.
Criminal appeal 383 of
Item numbers.
item number 62. 62.
For 62, it is submitted by learned appellant that paper book has not been received by him. Till date, registry is directed to fund. Is this was 50?
62.
2, okay.
In serial number 62.
That is the only item where the paper book is yet to be received.
Yes. In 63, I have received.
What is your item where you have lost your client?
In both.
Item number 59 and 61.
In both the same.
Item number,
He is common. In both FIR, he is common.
but we have to pass orders in each. Item number 59 and
61.
5961, learned counsel for the appellant submits that of the year 2013 and he has lost communication with her client. That is the appellant. A local person or from outside? We issue court notice. You have their address.
Related case, no?
Address is father's name.
So you have to contact them. Write to them.
Contact. I'll also write a. In meantime, I think CBI is the best person. And really, your lordship, in another appeal also that it happened like that, and they got the information.
CBI will send someone to Surupatan now. What?
October.
Petitioner to take step. 3 days. Court notice. Then we are done with 59. 61.
Yes, Lordship. Now 60, Lordship. I am appearing in item number 60, Lordship. Criminal appeal number 347/2013.
Yes.
So in this case, Lordship, I received the paper books, Lordship, but the exhibits are not received.
Item 60, Learned Counsel submits that paper book has been received without the exhibits. Registry is directed to furnish copies of the exhibits.
Paper book all over right?
My one request is to the lordship, some time bound may be given, otherwise it is pending from 13.
Within 2 weeks, okay.
In 2 weeks or for serving the paper book.
Yes.
Three weeks is necessary, 1 week in Bihu holidays.
For serving the paper book, that is the legal process.
That-
If time bound is
That
not
that
there,
only, that.
yes,
That no,
then
Then
Then-
63. 63 are done. 63 is over, I think.
63 over.
59, 60, 63, one set. This is.
We're done with all then.
Lordship.
Is the matter sobre eta commanded did you?
Much obliged.
It is. Of course.
That's
Bye.
Lordship, Mr. Emma Chaudhary has engaged my senior, Mr. M.H. Ahmed. Lordship, he has undergone surgery of gallbladder. So he is not able to come with brief of the case. Matter may be listed after the vacation.
It is submitted on behalf of the petitioner that Learned Counsel appearing. Petitioner is recovering from surgery. And accordingly, further time is sought. Is the matter again on. Yes.
Yes, Lordship.
Please, my lord. So this matter arises out from a quashing petition, my lord. We have challenged the impugned cognizance order, my lord, of the lower court, JFMC Borpeta. My lord, will kindly find the complaint case, my lord, at page number. Annexure 5, mate. Page number 33. My apologies, my lord. It is page number 24, my lord. My apologies. Sincere apologies, my lord. 25, it operative part, my lord. May I read? It says that, my lord, with due respect and humble submission, the applicant begs to state that he is the resident of the aforementioned locality. All the accused persons are of dishonest nature. In the year 2000, the applicant and the accused number 1 got married with Mohammedan laws and customs. With such marriage, the applicant and accused number 1 gave birth to 2 male children. The names are so-and-so, age so-and-so, and so-and-so. At present, Shiraz Khan is studying in so-and-so college, and Rajiv Khan is studying in class 7 at so-and-so academy, Howley. Soon after the marriage, the accused number 1 had been torturing the applicant both mentally and physically. That 6 months before the occurrence of this incident, the applicant gave the below mentioned documents to accused number 1. My lord, applicant is the husband of the accused number 1, my lord, and she kept those documents into her custody. It seems like the applicant, the husband, gave documents to the wife, my lord, and she kept into her custody. But the accused number 1, with ill and advice of the other accused persons, stole the below mentioned documents on 7/3/2022, my lord. May I request your lordship to kindly mark this date, my lord, 7/3/2022, and the money and kept in the aforesaid residence of the accused persons, in result of which the above said children of the accused could not submit the.
You are against the order of cognizance.
I'm against the order of cognizance.
Where is
The
that?
my lord. Pardon, my lord.
Where is the order of cognizance?
Order of cognizance, my lord, your lordship will find it at Annexer 6 series, my lord. Specific page number.
His number?
Yes, my lord. Page number 46. 40. Yes, 36, 40. It's taken cognizance under my lord 406 criminal breach of trust. Now, this lordship, when I said lordship to kindly mark the date, that was the very date, my lord, I was thrown out of the house of the applicant, my lord. There was a matrimonial dispute between the applicant and me, and I was thrown out of the house of the applicant, of the complainant, my lord. And thereafter, my lord, I filed 2 cases, my lord, out of which one has been compromised, and the another one is still pending. Now, when those cases were pending, my lord, in the meantime, he has filed that complaint after 6 months of the occurrence of the incident. And now, my lord, ingredients of criminal breach of trust are completely missing here. And there are also legal issues are also there, my lord, because in this chapter where there is an entrustment, my lord, the main thing is there is no entrustment, and they could not show as to how I have, my lord, misappropriated with that property, or how I have.
Where is the complaint?
My lord. I complaint?
No, this is his complaint, isn't it?
This is his complaint. My complaint, my lord, lordship will find it.
No, we are not on your complaint.
Yes,
We are against the taking of cognizance on
Yes.
his complaint.
So this is the complaint, page number 25, my lord. Basically, his complaint is that the husband gave some documents to the wife on the same day when he threw out, when she came out of the house on 7/3/2022, and she took those documents and in her possession. So, my lord, there are no ingredients of entrustment here. It's totally a personal, my lord, upon husband and wife giving documents personally, and everything is at his only possession, my lord. Nothing has been taken by me. I was thrown out of his house. I was brutally tortured. I was thrown out of his house. And, my lord, the legal issue here is that there are, lordship will kindly find in the complainant, there are almost 5 numbers of witnesses. Total 5 numbers of witnesses, my lord. And trial court records goes on to show that only 3 numbers of witnesses have been examined, my lord. And, my lord, 199, my lord, CRPC clearly says it's 200, my lord. Married, examination of complainant. A magistrate taking cognizance of an offense of complaint shall examine upon oath the complainant and the witnesses present, if any. It clearly says, my lord, and the witnesses if present any. There are 5 numbers of witnesses. And lordship will kindly, if lordship kindly have a look in the quality of the witnesses, it's all, my lord, frivolous. It seems like it has been made up. It's totally, my lord, a case out of personal vengeance. That person applicant is also a police officer. He did not file a case to the police, my lord. After 6 months, when there was an interim maintenance, my lord, I got an interim maintenance of 5,000 just to bargain those cases, my lord. Just to bargain my capacity of maintenance so that I can
I do not demand that much maintenance, just to bargain with those two cases. Now, one of those cases, my lord, CRDV, I have instructions that that case has been mutually agreed and that has been dismissed, my lord, withdrawn. And at present, MR case is there. And my lord, when that case was, my lord, on mediation, those cases was, my lord, quashed, the CRDV, there was a promise from the complainant he will withdraw this case. But till that is of course off the record, I cannot press it. But prima facie, my lord, this lacks criminal breach, ingredients of criminal breach of trust. Further, 1/200 examination of complainant, my lord, is there. And my lord, may I kindly request your lordship to kindly have a look into this judgment. Now, at present, the complainant and the victim, my lord, the complainant and the accused, my lord, they are of different locations. So their addresses, my lord, their this court has this cognizance order has been taken by Judicial Magistrate First Class Borpeta, and I stay here in the district of Dhubri. So when there is a jurisdictional issue, my lord, now section 202 is all clear than this. May I present this judgment, my lord? When there is jurisdictional issue, my lord, now the very first thing the magistrate ought to have done, paragraph 8, my lord, I am relying upon.
What is the jurisdictional issue here?
Yes, my lord, the complainant resides in the district of Borpeta. I was thrown out of the house of the complainant. I am staying with my father's house in Dhubri district. Now, the cognizance order has been issued by Judicial Magistrate First Class Borpeta.
You reside in Dhubri.
Yes, I am residing in Dhubri as of now, in my father's house. And when there is jurisdictional issue, my lord, that I have given that.
What is the jurisdictional issue? What
It says that, my
according
lord,
to which he cannot file this in.
No, he can file, but again, my lord, there is the issue, my lord. Lordship will kindly come to paragraph number 8, my lord. I will read that in Ajit Pawar versus Hemant Madhulakar, so and so, in another is Supreme Court judgment, my lord. Apex Court was pleased to observe as follows. Admitted position in law is that in those cases where the accused is residing at a place beyond the area in which the magistrate exercises his jurisdiction, it is mandatory on the part of the magistrate to conduct an inquiry or investigation before issuing process, my lord. That was not done here. So this is the judgment, my lord. And section 202 CRPC was amended in the year 2005 by the conduct so and so with effect from so and so by adding the words and shall. That shall word was added, my lord. So prima facie, when there is a jurisdictional, my lord, distance, so that section inquiry under section 202 is mandatory. It is written paragraph 8 and paragraph 9, both the given references of Supreme Court judgment, my lord. That's what I'm relying on. And further, I have said, my lord, there are 5 numbers of witnesses, only 2 were examined, 3 were examined. And quality of those witnesses, lordship will see there in the trial court record.
Yes. Yes.
It is basically on personal vengeance, my lord.
The learned trial court, my lord, after examining the witness under section 200 and 202, issue process against the petitioner, my lord. In order, page number 37, if the complainant and witness are present, they are examined under section 2 and 200 CRPC. Therefore, the question of jurisdictional inquiry
is
37, the order. Yes, sir. Examined under section 202. Therefore, my lord, the inquiry made by the jurisdiction, it will not come. The ground, my lord, prima facie materials after examining the witness, the learned trial court
hold that there are sufficient materials to proceed against the person under section 406. In the complaint also shows that I have submitted the list of documents which have been kept by the in her possession, my lord. The witness also supported the same. Therefore, there is no merit in this case, my lord. Primary materials found by the trial.
What jurisdictional issue, because of examination of witnesses under 202, that is not no longer available.
Worship.
That inquiry required under 202,
Not
that is not required when the witnesses are examined.
Worship. Cause of action arose, my lord, in Borpata district. After, my lord, he left the house and he can stay in any district within her own. Cause of action, my lord, within Borpata district.
What about prima facie no case under 406 being made out from the face of the complaint?
Yes, lordship, in complaint also, my lord, I have given the details of my documents. Who documents he has been kept away. The house, my lord, and the same has been, my lord, the witness also on oath and complainant also examined on oath.
So first, what is the subject matter of the misappropriation? Documents,
Documents only, my lord.
only documents. What are the documents?
Page number 27.
Whose land sale purchase agreement? Who?
Mine. Number 2, voter ID.
Whose voter ID?
The respondent number 2, PAN card of respondent, Aadhaar card, and school certificate of my children, my lord, admit card, everything. The Aadhaar card, school document, pass, bank passbook, ATM card.
Who is Rajiv Khan and Siraz Khan?
Children,
Children.
they are along with me.
Children documents, can you claim to be the sole owner? She is also part owner of those documents. Then where is the entrustment?
That she kept along with her only.
Have you stated anything regarding that these documents were entrusted to her? Yes, anything else?
I will just request your lordship to kindly come to the trial court records, and lordship may kindly have a look into the witnesses, my lord. The witness in deposition of the first witness, my lord, it is Amir Hussain Khan. He seems to be the uncle of the complainant. He says that now they have tried to prove this entrustment by virtue of this witnesses, my lord. My lordship may kindly see, he states that I am the uncle of the complainant. In the month of so and so, he handed over it seems that in front of them, my lord, all the three witnesses, deposition 1 Amir Hussain Khan, deposition 2 Nazrul Islam, deposition 3 Abdul, this all are third party. Will a husband, my lord, call third party and give all these private documents to them? They have tried to show this as an entrustment to constitute 406. Now this seems that just will a husband, my lord, call a third party and give all these documents are, my lord, private documents, my lords. These are not something an award and all. So will a husband, my lord, call a third party and give all these documents? Look, I am giving it to my wife. They have tried to show this as entrustment. So prima facie, my lord, it lacks 406.
I cannot, my lord, call a witness from Dhuri, from other district. He can also submit evidence.
And I have also,
He can also examine witness.
I have also, my lord, challenged that 200 because all the witnesses have to be examined, my lord. It says language that, and it says clearly says that complainant and the witnesses present. There are 5 numbers of witnesses. Where are the 2, my lord? If 200 has not been complied with, my lord, so my lord, then 202 that proviso will not be complied with. Just hold on, please. If 200, my lord, has not been complied fully, now how can 202 be complied with? So when 202 proviso is there, but that proviso cannot be applied. It does not say 1 or 2 witnesses. It says and witnesses present if any. So when they have given 5 numbers of witnesses, the deposition has to be 5. And my lord, this prima facie lacks, my lord, 406. Prima facie lacks 406. There's nothing for entrustment. And they could not show that how can I have misappropriated those or converted those property into my use, my lord. They have not showed that. This prima facie, my lord, arises out of, I have also given those documents, my lord, MR case number, just to bargain that. Nothing else, my lord. He's also a police officer, my lord. After 6 months, he's going to the court, not even to the police. He's also himself is a police officer. He could have gone to the police. He could have managed a seizure to my house. Nothing, my lord. After 6 months, out of a sudden, when the trial court gave maintenance order, when he saw that I have to go to the district of Dhubri day by day, just to pressurize me, just to bargain me, that is. Just to bargain with those 2 cases, my lord. And my lord, I'm a very poor lady. I'm getting just 5,000 or 6,000 of maintenance. So, my lord, kindly, this has to, my lord, the cognizance order, prima facie lacks merit, my lord. The 406, particularly 406 criminal breach of trust, it lacks merit.
All right, CAV.